Yes.
Maybe. My lord, I'm making a mention in respect of item 14. My lord, the appellant, my lord, is a life convict, and presently, my lord, he has been serving out this sentence. Now, what has happened? Pursuant to the honorable court's direction, my lord, process, my lord, for remission of his sentence, my lord, has already been initiated. Now, regarding, my lord, the progress or outcome, my lord, I don't have the latest instruction. So, lordship may fix it after 4 weeks or 6 weeks. In the meantime, my learned friend may obtain
But
this.
that has always been the issue.
My lord.
That is always the remission, whether it's going to happen or not, that's a different issue.
No, my lord, in fact,
2018 matter.
yes, yes, my lord.
Yes.
In fact, your lordship, my lord, this matter came up before your lordship, my lord. And your lordship had, in fact, my lord, adjourned the matter and my lord asked me, my lord, to my lord, initiate the process. And therefore, thereafter, my lord, this matter was deferred, my lord. And in the meantime, another order has come, my lord, order dated 4/8/23, where this honorable court has, my lord, in fact, also granted liberty, my lord, to the authorities, where, my lord, they felt that the appeal has come in the way. So this honorable court has made it clear that the pendency, my lord, will not be an impediment. So that process is going on. Lordship will fix after 4 weeks. In the meantime, if my lord, the process is, my lord, my lord, is culminated or about to culminate, then, my lord, the matter will be closed, my lord.
You should have given a prior written application.
Yes, Lordship.
That is correct.
You see, already,
No, in fact, your lordship has already heard the matter, my lord, in the month of March, my lord. Already, my lord, I have completed my submission. Thereafter, your lordship had passed the order, asking me, my lord, to write, and I have made certain, my lord, communications with the jail authorities also, my lord. That because, my lord, on my part, I have already completed my arguments, my lord. In the month of, my lord, March itself.
okay, right. On the prayer of Mr. S.K. Talukdar, Lord, I might just to submit that the state government is considering remission of the sentence imposed upon the appellant. And as such, the matter may be adjourned. Ms. S.H. Bora, additional GP, submits that is directed to obtain instructions with regard to the status of the remission proceedings pending before the state government. This is the matter after,
And Lordship, after 4 weeks,
after 4.
Obliged.
a copy of the order may be furnished to us, Lordship.
Copy of what order? This one.
This order, Lordship.
Why don't you download it from your,
Lordship, that will also,
it will be,
Yes.
be uploaded anyway.
yes.
Obliged.
Mr. Talukdar, can you meet me
My lord.
at around 1 o'clock?
My lord. Correct. Obliged.
With due respect, my lord, I am paying for my lord, listing for tomorrow, my lord. I criminal for bail, my lord. Temporary bail, my lord. Obliged. We have notified victim is item 15. My senior is out of town. The concern of planet PP, matter may be adjourned for today. After 2 weeks, in it.
Where is your written adjournment slip?
No, your. Yes,
Huh?
urgency, your honor. My senior is out of town.
Maybe, but then as the High Court has issued a notification that all adjournments have to be made by way of a prior adjournment slip.
My senior was about to argue this matter, but there's some urgency,
What urgency?
some personal difficulties there.
What personal difficulty?
That was I not, don't know.
What do you think we are doing?
I will
We don't have
ask
personal difficulties also. Or what? You're supposed to inform us.
That time my senior has informed me to adjourn the matter. He was about to argue. I have the file.
But he should give you the reason. What to do?
After BU, Rashid. Any day.
Why after Bihu? Why not tomorrow?
I have to ask whether
Huh?
he will come or not. I don't know.
This is not the way. Otherwise, all matters are being adjourned.
Matter of 22, Rashid.
Huh?
Matter of 22.
Mr. Counsel, it's in the list. Whether it's of 23,
Yes, sir.
or 22 or 17, doesn't matter. It's on the list. It is listed for today. It is not listed in the cause list to be heard in 2029 or something like that. It is for today. On the prayer for adjournment made on behalf of Mr. Nuddin, learned counsel for the appellant who is apparently out of state. List the matter after the bill reading.
Maybe so, Lordship, back to mention item number 11, Lordship. Lordship, kindly adjourn the matter for today and maybe next after people.
Huh? Is the 2017 matter?
Yes, Lordship, today, it's Angus Senior Counsel, Jack Kamal.
Just give me this item 11. This has been adjourned on behalf of the appellant. On the last 5 occasions.
Yes, sir.
Then, huh? No, 5 occasions. We'll appoint an amicus if you don't want to appear. We'll appoint an amicus. You will appoint amicus, we'll hear the matter.
Lordship, after vacation, any date, Lordship.
Did you hear me? Did you hear what I said? Do you understand what I said? Yes or no? Did you understand what I said? No, you didn't understand. We will appoint an amicus and we will hear the matter. If you are not willing to appear.
Lordship, only one opportunity may be allowed.
Last 5 dates, you'll have adjourned the matter.
It was hard at land once, the another bench.
Yes.
And I have got the written submission also with me.
I know, just heard at length by Justice
Another bench.
Koteshwar.
I think in court number 5. Court number 5.
On 22/9/2021.
After that, madam.
No. Here, 22/9/2021, heard so, hearing remains inconclusive. Hearing will continue on 29/9.
My written submission is dated 2/3/2022.
True.
22, madam.
Right. Prayer for adjournment has been made on behalf of Mr. Z. Kamal, learned senior counsel for the appellant. It is noticed that the appellant's counsel has made a prayer for adjournment on the last 5 consecutive court dates. And the matter has been adjourned accordingly. The matter pertains to the matter relates to the appeal filed in the year 2017. What is the matter about?
The appellant is in prison for life imprisonment, Lordship.
Huh?
Appellant is convicted for life imprisonment for 302 IPC.
302.
Yes, sir.
Any
Two
eyewitness?
persons have been killed, there's
Any
a
eyewitness?
statement. No, there's nothing, no one.
This is the matter after the Bihu quotation.
May I please, Your Lordship? Your Lordship, I beg to mention item number 10. Your Lordship, my senior counsel, S. Borgohain is appearing in Manipur High Court for number 1 regarding this ST matter, Your Lordship. So right now, we don't know how it's for admission, admission hearing, Your Lordship. So we don't know how long it may take, Your Lordship. So kindly.
It won't
adjourn the
take that
matter.
long. It won't take very long.
Your Lordship, this is a sensitive matter, Your Lordship. So we don't know.
Everything is sensitive, Mr. Counsel. That's why we are here.
Yes, Your Lordship.
What do you think? We are here just for the easy cases or what?
Your Lordship. kindly-
Because the other matter, 1 to 6 is being adjourned. You all want to do.
Yes.
But then if we do 3, 4 and 6, that will have a bearing on,
No, it's regarding payroll.
on the miss case, not on the main thing.
No,
Okay, okay. And what to do? 2016 and 17 matters, Mr. Counsel.
Yes, Your Lordship.
Huh?
Lordship, my senior has already communicated with the CBI.
Lordship, today he has made a call, today morning, Lordship, that he is preoccupied with one case of Manipur. Lordship.
You had a duty to inform us yesterday by way of a German slip.
Otherwise, Lordship, there are also total 4 accused persons. Already the other 3 accused persons already made their argument, Lordship. With regard to him only, it was pending. May I pray your Lordship to kindly fix immediately after due vacation. Last chance may be.
Last time may be given, Your
22,
Lordship.
and on 25th can be disposed of. Lordship. 22nd, Lordship. Immediately after due vacation. Last chance may be given.
I think they're just delaying the matter, that's all.
Your Lordship, last time. may be given.
I think no ransom was paid and then
Yes,
that person died. Killed,
yes, that matter, Lordship.
kidnapping.
Kidnapping, extortion, Lordship. Dacoity,
Which item, in which court, which item is senior in?
Your Lordship, this is the post list for Manipur High Court. Item number 8, Your Lordship. Item number 8. And this is the last one, Your Lordship.
Admission hearing. Who is your senior?
S. Borgohain, Your Lordship. Your Lordship, his name will not be reflected in the cost, in that cost list, Your Lordship, because only the advocates who filed the.
Where is he? Where is he?
Your Lordship, he is doing it through VC right now. He'll be
He's
doing
doing
it
it
through
through
VC, Your
VC.
Lordship.
We'll wait for him. He won't take the whole day.
Your Lordship, but as per the instruction, Your Lordship, this should be, if it could be adjourned for today and would be listed after the Your Lordship, it'll be better.
No, no. Why should we,
Your Lordship, last chance may be given.
what last chance? This way to will never do any work. There'll be a paid holiday for us. And then y'all will say that the judges don't work.
No, Your Lordship.
So 7, 8 and 9, we heard them. So they finished their argument. So some notes were made? Or not? No notes. I remember there's some kidnapping, ransom not paid,
Yes,
died.
yes, yes. Brutally murdered in the jungle, Lordship.
Then they were seen across the bridge or something. What is it?
Lordship,
How were they caught? How was the accused caught?
they confessed, Lordship.
Confess. Okay. Confess. Yes, yes, confess. But then the thing was that, yes, then they
Retracted it,
retracted it during 313.
yes.
Now, whether
3-1.
there can be a retraction of a confession in the 313 stage,
And
that was one of the issues.
Yes.
yes, and the report was not given by the IO.
What report?
The charge sheet was not filed by the IO, if I'm not.
Charge sheet was not filed by the IO, so whether that is again, that does it cause prejudice to the accused?
Yes, Your Lordship.
So
That was
those
my
are the 2 points only, that nothing else.
Finally, last chance may be given.
No, we'll wait for you. You come, you will wait. He'll not take the whole day. We will also check through the VC whether this thing, we check later on whether this matter item 8 is disposed of, is finished or not. It's a Manipur High Court. You can ask them, not a problem. We'll see. We'll check with the Manipur High Court whether this matter has been disposed of or not. I mean, has been, the serial number has been, passed over. We'll see. Next. Yes,
Wait, please, Joshua, I beg to mention item number 5 of the disease. Finally, this maternity June
item number 5.
5 days. Yesterday, I have
Yes. Heard Mr.
S.A. Borbuya.
S.A. Borbuya, Learned Counsel for the Apparent. It's for adjournment. Just give me item 5. They have not prayed for it. Item 5. Item 5. Okay, right. Adjournment prayer has been made on behalf of the appellant's counsel, which is not objected to by the learned addition PP. As per office note dated 28/8/2023, notice has been issued to the respondent number 2 by registered post with AD. And the same has been returned unserved. Where is that? US. With a note from the chief, from the CJM Dubri, which is to the effect that notice could not be served upon the respondent number 2 as the jurisdiction of Pancharatna police station did not fall under the district of Dubri. Accordingly, the CJM Dubri has requested for issuing of the notice in the proper address of the respondent number. What is the proper address of the point number 2?
Lordship, I need to take some instruction and we can serve through PP also. We can serve the notice to the proper address, Lordship.
This is anyway 302, na?
Yes, Lordship.
Uska. The above being said, comma, the matter pertains to conviction under section 302. And as such, in terms of the division by judgment of this court in that, what is that? Pyongyang, what is that? I'll give you the. Huh?
Bormoti Pangin.
Bormoti Pangin versus what is the citation? Have you got it?
Lordship.
You just give it, huh?
Not.
Notice need not be issued. So that is point number 2. Full stop. Further, office note dated 28/9/23 states that LCR has not been received in the concerned section as yet. Full stop. A registry to send a reminder for the LCR. Has it been received?
Received.
Received?
Received in item number.
Why is it not reflected here?
In item number 7.
Item number 3, we do not receive.
It's here, item number 6. Item.
Oh, it is
Item
there.
number 6.
Okay, cut that. It is seen that the LCR has been received in the analogous case, that is criminal appeal 306/2023. Registry to prepare the paper book.
Lordship.
Leave the matter after 4 weeks.
Deeply obliged, Lordship.
Okay, I am for item number 1.
Just a minute. So item number 1, which one do you want, Arjun?
Item number 1, he wants.
1, 2 and 5.
1, 2, I am for 2.
1, 2.
I am 2, 8%.
Okay, wait, just a minute. In 1, in 5, in the 389, have you filed written objection?
Objection filed, Lordship.
Huh?
Objection filed.
Objection filed in 5. 1 and 2 also filed. Everything. So you know why? So why? What is the problem? Why do you want to adjourn? 1, 2 and 5.
Okay, my senior has some difficulties.
What is the difficulty? This is a 389. What is if the paper? If the NCR is there, what is the difficulty?
No,
That has been, Lordship, objection has been filed in item number 1, Lordship,
2,
in 2 also.
and 2 also.
5 also.
5, we do not have the record.
One, 5 we are in. 5 not here.
5 is
5 has not been filed.
not filed.
Not filed. Lordship.
Okay, in item 5, no, in item 5 in the IA, you're right. Mr. S.H. Bora is granted 2 weeks time to file written objection. This is the matter after the leave of vacation, huh? What about 1 and 2? Why should we allow?
Objection filed, Lord.
Huh?
They have filed their objection.
Correct. So we can hear the matter. Yes. Anything else? You have the file.
Lordship, I beg to mention for listing of one appeal, Lordship. It was filed on 3/1/24, Lordship. For tomorrow, Lordship. Obliged, Lordship.
And item 5, we said paper book always. So paper book has not been made, no? So it's all the same. It's one analogous stuff. So I don't think paper book has been made in any of the.
Paper book not yet prepared, Lordship.
Not prepared. Anyway, it doesn't matter. Okay, make it 4 weeks more.
Item 5, no?
Yes,
A copy of the IA may be furnished to us, Lordship, by my knowledge. We have not
Correct.
received that.
then how did, without the IA, how did you
Yeah.
file written objection?
Yes, we have not filed it here. Lordship.
Huh?
It's not there. They're supposed to give us, Lordship.
You have not filed what?
We have not received, Lordship, the copy of the IA in item
Give
number.
me the
At
IA.
the time of filing, Lordship, we start the copy.
Actually, it is not here. Written objection is not here.
Lordship.
Have you filed it or not?
No.
Yeah? And they said that they have received a copy.
Item number one.
We don't have it now.
In five, Lordship.
In five, no,
Then-
five, I'm talking about one.
Yes, that is their Lordship.
Then,
In one, we have filed objection, Lordship.
yeah, filed.
Yes.
This is there. Ah, it is there. It has not been marked, yes. So what do you want?
Lordship, as per management wishes, Lordship, they want to go for argument, then we have no objection.
Yes, let us go.
Lordship, kindly fix a short date, Lordship. Because Lordship, my senior's presence is required in this case, Lordship. अब आगे दे दीजिए।
हाँ, sir.
Your FLN number?
Lordship, 1, 2, 3, Lalchan, Wahab and Jamaluddin, Lordship. Please ask him, Lordship. Lordship,
1, 2,
1,
Lalcha Mali.
Lalchan, Lordship, accused number 7, Lordship.
Okay, we'll list it tomorrow. We'll be ready tomorrow. Item one. On the prayer of the council for the appellant. List the matter tomorrow. Item two also tomorrow. 1 and 2.
1 and 1.
Obliged, Lord.
Not 3 and 4 with here. I think 3 and 4.
Objection copy to give. 3 and 4.
So I think 1 to 6, they are all out of the same judgment and order.
Yes, my lord. Now here, my lord will kindly take a note. Date of occurrence happens to be 21/6/99. And date of reporting with regard to lodging of the affair is after 2 days, that is 23/6/99. Now, two persons are victim, my lord, this is persons, two persons. One is Sahar Ali and one is Jahar Ali. Now, my lord, the charge sheet has been submitted against 10 persons altogether. If your lordships go through the lower court records, so far with regard to this accused person, that is Hassan Ali, while he was arrested and my lord produced before the trial court, committal court below during investigation, his age was shown to be 52 years. Now, in the charge sheet, it has been shown, my lord, that he expired. That I have from the records I'm saying. Even then, he's been appearing in the court and he's been convicted, my lord. He has been convicted, my lord, for various of 147 is 1 year, 148, 2 years, 302 RI for life, 201 by 149 for 2 years.
201 by 49.
Yes, 149, my lord, 2 years. I have asked my learned colleague to check the lower court records. It will be reflected that he expired on, it's been shown on the date, my lord, happens to be somewhere in, yes. Next page. Yes, 28/2002.
Expired on
28/2002. He has been shown to be shown
20.
202.
2008.
2002.
No. 20 means
20.
20.
20. Yes.
20
August.
August, 20th August, 20 August
2002.
2000.
Yes. Subject to correction by my learned colleague. Now, here in this case, my lord, 20 witnesses has been examined. So far Hassan Ali is concerned, my lord, his 313 statement shows his age to be 35 years. Wherein the forwarding report after arrest, his age is shown to be 52 years. And if it is 35 years from the 313 statement, then on the date of occurrence, it will be about 14 years. Date of occurrence is 21.
313 is which date?
313 has been recorded, my lord, in 2020. And his age is been shown as, my lord, 35 years.
Wait, you give us the date 313?
It's been recorded 14 February, my lord, 2020. That's a Valentine Day, my lord.
2020.
14 February 2020. His age to be shown as 35 years. Now occurrence is of 21 years ahead, 99.
So he would have been 14.
Minor. And here also going to the prosecution witnesses 20, my lord. My learned colleague has filed their objections that PW 5.
Okay, now one thing,
Yes,
but you said that he's died.
absolutely. That
Now-
is confusing part.
Now what's
Because
happened?
in the charge sheet itself, it's been shown expired on so and so forth. He's been tried, my lord. And the forwarding report, my lord, is 52 years. And here he happens to be a minor, my lord.
Let us see.
Yes, my lord, lower court record has been there before the court.
Let us see from the
I
file.
have flag marked the lower court record with regard to forwarding. Forwarding, my learned colleague has did the homework, my lord. And she has flagged it with regard to the age of the penis. The flag mark will kindly see the forwarding after arrest is 52 years. Green color.
This bandit.
Page 2 is what we, that much told is what we-
That's marked with green color flag, my lord. Straight away, my lord, shall go there. It stopped, my lord. Upward us.
Inquest.
No, previously it is there. Green mat, green, yes, that one.
Impact.
Yes.
That is inquest. What are your file?
No, my lord, there is another green one. In front, I think so. Forwarding. Bloody one, photo. May I assist the court, my lord? Lydia, find the
Yes.
Yes. Now, as for the objection that has been filed, my lord, according to the prosecution, my lord, PW 5, 6, 8, 11 are the eyewitnesses. One is left out, that is again 15, that is not been mentioned.
Yes.
As for the objection they are filing, 5, 6, 8 and 11 are the eyewitnesses to the occurrence.
Just a minute.
5, 6,
Eight.
8 and 11.
11.
But they left out 15. 15 is also a eyewitness, my lord. In the objection, it is not there. I have to be candid and fair with the court. 15 is also been there. So far, 5 and 6 is concerned, my lord. They have been brought to give evidence in the court from the jail. Because these accused persons, family members were killed by that particular 5 and 6. And for which they were, my lord, undergoing jail term.
Okay.
So they have been brought to give evidence from jail, 5 and 6.
Who killed whom first?
These particular persons who were in jail, their trial was going on, my lord,
They had killed whom?
not arising out of the same incident.
different earlier
Yes.
incident.
Yes. So, my lord, it's not a case and a cross case. It is a different incident. They at first point of time, my lord, killed the family member of this particular persons, my lord, who is being accused in here. And they were tried and convicted by a court of law. And from jail, they have been brought in to deduce evidence. Now, so
How
far,
does
five
that
is
so what does that point to? What are you
that
trying to say?
shows with regard to that inimical relations, to what extent one can go. And that is demonstrated by the evidence itself in the court. Why I'm saying so, my lord, that's been from the
No,
evidence of,
so wait a minute. We're talking about Hassan Ali, no, right now.
yes, Hassan Ali, yes.
So Hassan Ali,
He's a juvenile,
no, that is one aspect.
yes.
One, the thing is that was there the eyewitnesses saw him
I'll come to
assaulting
that,
the
my lord.
assaulting.
So far, PW5 is concerned,
Okay, Hassan Ali.
that is 52 years, my lord. And can you see Hassan Ali, 52 years? Will I decide? So far, Hassan Ali is concerned, my lord, in the chief, examining chief, he stated that the other accused persons,
What is this document?
Hmm?
What is this document? Oh, acha, by the-
after arrest, my lord, forwarded to the court of law.
To the court.
And it is 52 years, my lord, if I am
That could
correct.
have been a mistake,
May not be, my lord. 52 and 35 are two different.
but even so,
And even the charge sheet, my lord, will kindly see.
so assuming it was not a mistake, then as per 313, he's
And
a
my lord, will
juvenile.
kindly see the charge sheet. It's been
Ah.
crossed, expired on so and so. It's been written in the charge sheet, which is the practice we do it. Kindly see the charge sheet. Now, my lord, PW5, why it is to be disbelieved?
Ah.
My lord, he stated with regard to this particular Hassan Ali, what is his statement? The other accused person, Hassan Ali, and he named other accused person, assaulted and hit the victim by sharp weapon. As a result of such assault and hitting by sharp weapon, the victim, Jahar Ali, breathed his last. This is his examining chief, substantive evidence. It has been suggested during cross-examination that you have not stated as such before the police in your 161 statement. And he denied it. Ayo has proved it. Am I clear, my lord? With regard to inimical relation.
Anyway, that I think that yes, what have you got to say with regard to the age?
Hello.
According to the 313 statement,
Lordship,
I don't know if you have got it here. It says that in the 313, I don't know, let us see
35
the 313.
years.
35 years.
35 years.
So if he's 35 in the year 2000, in 99, which is 20 years earlier, he would have been 14, 21 years earlier, he would have been 14 years.
Lordship. That's
Whole trial
Lordship, but
basis.
So he's a juvenile.
he's juvenile at that point of time. But Lordship, every eyewitness has said his name, Lordship.
No. We're not on that.
Ah. Lordship,
We're not
that
on that.
one he was
We're-
juvenile.
So if he's a juvenile, can we put him in jail?
But at that relevant point of time, Lordship, whether that point was argued or not, that
No,
was
no, this is the issue of age.
age, Lordship, but at that point, Lordship,
Now there is two parts. One is that at the time of production,
production.
he was stated to be 52 years by the police.
Lordship,
That was, I think, in the year 1999. 52 years. And in the charge sheet, he's shown to have died.
Expired on, my lord, it's been
That's
written in
what
the
they
charge
say.
sheet.
According to the applicant's counsel,
20,
he's
charge sheet
supposed to have died.
28, 2020, 2002.
Now, assuming that he did not die,
Yes, sir.
what is his age?
at that point of relation. Lordship, let me.
Let us see.
That's what it is, my. And the witness is not identified this particular as a witness, my lord. And whole of the evidence, if your lordship says Hassan Ali, Hassan Ali. This is that Hassan Ali that's not been done and which is been the requirement of law.
Let us see the C1 thing. C1 thing.
Let's do it. Maybe GM is trying to commit.
They are all in Assamese, so. Luckily, my sister is here to read it. No, nothing. Yes. Are you sure there's only one Hassan Ali or there are more than one?
I have checked the charge sheet, my lord. It is only one Hassan Ali. Another witness is there, Hassan Ali. Witness, same name.
Hassan Ali witnesses.
Yes.
PW2, he is Hassan Ali.
Yes.
PW2.
Okay. So we have got one accused Hassan Ali and one witness.
Lordship, I'll have to go to the LCR, Lordship.
No, you will go through, we'll go.
You know, because we'll have to find out whether these two persons are same or different, Lordship.
No, but how can it be? They have to be different. You
Different,
cannot have one person being a prosecution witness and being the accused also.
Lordship, that is also there, Lordship. I'll go
Him,
through, Lordship, I'll go through. Because I'll need.
I agree.
Person.
35 years.
Certain time. His name is Chandula, that's his name. It is different. It's the. That's the idea is.
Whatever it is, everything is different. At the time of the interview, there was only 14 years old. Why should he be engaged?
And my lord will kindly see the charge sheet. That particular accused person who was charge sheeted, father's name is different.
That is why.
Yes. দেবতাকর নাম কি কইছে?
Another accused is there, Hassan Ali.
Yeah, two accused.
Yes.
Two Hassan
Ghulam
Ali.
Mohammed.
Okay, one is 52 years and this,
And
the other one is 35. So he was minor. So we believe him on the.
26. That's what.
Huh?
The minor. This only on the basis of this book alone.
Huh.
You have to input the matter.
বাপের নাম কি?
Any
Yeah,
documents, 26 as per.
সানুল্লাহ।
26 years old.
Yes.
In practically is what thing. He could be much around.
99. 99 is incident report also in the year 99. Which is
How old was he in 99?
26 as per charge sheet. One is another boy. Alice, mother, and father's name is Ashraf Ali. That is, he was examined, and another Hassan Ali.
So there is a
Hassan Ali.
mistake in the T1
Oh, maybe.
Very.
Sit it, sir. I'm leaving that with it. Yeah, I'm 35 years. So nothing.
From all the sides, he's a minor.
No,
And apart from that, my lord, can you see?
no, he's not a minor because there are two Hassan Alis, it appears.
Yes, one is witness.
No. Both two accused.
Yeah.
One is Hassan Ali Mandal.
Yes,
He was sworn as absconder in the churchship.
okay.
His
Now-
father's name is Askera. Father's name is different, Asker Ali, and another is Hassan Ali, who expired. Who expired and the case is abated against him.
In the charge sheet, my lord, it's been shown as 26 years. Yes. Then, my lord, charge sheet has been filed on when?
99.
99. So, he's been less than, my lord,
No,
no, 26.
incident occurred in 99. That sheet filed in 99.
Charge sheet is filed in 99, my lord. He's been shown as 26 years.
Yes.
Now, the person who has been tried before the honorable court, his father name happens to be, 313, it's different.
Okay.
Father's name is, my lord, Akhir Ali.
Yes.
Yes,
Asker Ali, same. Mandal is.
That is Lordship, he is accused as three.
That Hassan Ali Mondal is been shown as absconder.
Yes.
And he has been not been shown, my lord, as expired. What has been shown as expired?
He was subsequently he appeared. Present is there.
Huh. So, my lord will kindly see the person facing the trial.
I think you have to address your arguments all in Assamese. I've got.
No, my lord, the accused, my lord, that's been facing the trial, 10 accused person, my lord.
This
Is
Hassan Ali.
Hassan Ali-
Three.
Habibul Laskar Jamaluddin Wahed. And this is never appeared before the court. Mondal
Yes, Hassan.
never
Ali Mandal.
appeared before the court.
Yes, he was present. Present.
And for that purpose, if your lordships feel in that manner, wherein we have taken a plea of juvenility and the whole conviction goes, my lord has all the powers to direct the officials to ascertain his age. It can be done.
That is a different issue.
But from the face of the record itself, my lord, it appears that he is a minor.
No, it doesn't appear so. In the charge sheet.
Because arrested accused person happens to be 52 years from the
No,
forwarding.
Anyway, there are two accused. As per the charge sheet, there are two accused persons having the same name.
No.
One
One
is
is
a-
Mondal, additional Mondal.
One is Mondal, one is without Mondal.
Yes.
But both
So
of them
far
are
Hassan Ali is concerned,
Both of them are Hassan Ali.
no, both Hassan Ali, Mondal, Hassan Ali. And Hassan Ali happens to be 52 years from the forwarding. And that is dated, my lord. That order, my lord, in the forwarding is 8799. Forwarding report. Hassan Ali, Mondal. Absconder, we have nothing to do with that particular thing.
Check the pastor.
Hmm? Hmm? Even on the merit of the case, my lord, I respectfully will submit, my lord. It's a case for granting bail because every sons of my lord acquittal in this case. If your lordship appreciate evidence of PW5, who according to them is a eyewitness, my lord, he has stated all these things for the first time and not in previous statement and omnibus statements. And he has been brought from jail. Similarly, PW6 also brought from jail, my lord. And he kept, my lord, FIR has been lost after 2 days. He kept mum with regard to this. Didn't say anything to the neighbors, my lord, other witnesses. Didn't react with regard to what is happening. And previous statement he says with regard to place of occurrence is the market. Where here in substantive evidence it becomes different. So for PW11 is concerned, my lord, he don't even whisper the name of this particular accused person. With the aid of 149, my lord, all has been convicted. And with regard to specific overtake attributed, my lord, this is to the other accused person, not to this person. My lord. PW10 to 0. Taking a calculation by Computer board, yeah.
Was arrested. That person.
Hmm.
Subsequently arrested.
Oh.
27 years. During that period, his age is when he was arrested, 27. In the year, zero. 7 0, he was arrested on expense of plea. At freedom that we forward to definitely.
What appears from the records, my lord, I have not seen.
So he was arrested in 02 and that time he was 27.
No, no. As per the forwarding, 8/7/99, he was arrested, forwarded to the court. 8/7/99, that we have flag mark. Today morning, my lord,
That is Hassan Ali Mandal. Hassan Ali.
Mandal Niki.
But it's telling about
Hassan
Hassan
Ali.
Ali Mandal, not Hassan
Oh.
Ali.
99, 52 years. No,
No,
Mandal.
no. 7902, he was arrested. That is Hassan Ali Mandal. He was
7902 is not, my lord. 8/7/99.
99, that is different. He was.
Hassan Ali.
Already Hassan Ali.
Yes,
He expired and the case against him was abated.
yeah,
Subsequently, Hassan Ali Mandal, he was also arrested.
2002.
Yes, 2000.
And the person facing the trial, my lord, as for the 313 is Hassan Ali. That's what I am pointing out.
Hassan Ali. Father's name is Sam Akhtar Ali. Mandal is.
No, no, father name is different. Father name happens to be, my lord, is son of Sanaullah.
Plus, Sanaullah is.
No, no,
expired.
what?
That is Mondal.
What is my
No,
sister
no.
is saying?
Yes,
Mandal
Is that
okay,
Hassan Ali Mandal
yes,
was arrested in 2002
yes.
and his 313 statement was taken. However, in the 313 statement, that name Mandal has not been reflected. That's
Mandal is missing.
otherwise everything else is the same.
Maybe, but I have no idea because conducting counsel is different. But what I can point it out is this, that a person of 35 years and a person, my lord, below that or over 52 years, there will be difference. And if it is 30 years, 35 years, obviously he is a, my lord, minor.
No, but then you see, there are two Mandal. One is that Hassan Ali, who subsequently died. He was 52.
Yes,
Now, this Hassan Ali, at the time of his arrest in 2002, he was 27 years.
27, my lord.
27. So
If it
what
is
he has put
2002.
in
He's
his
27.
313 is either a mistake or he has intentionally given a wrong age or we don't.
So we cannot say all such things.
So you'll have to
Yes,
bring out some document
yeah.
to show that he was a minor at the time.
Minor, absolutely, my lord. that has not been even taken a ground in the
His
trial.
father is Akhiran.
Akira, Akira, he is a co-accused, my lord,
He is good.
in this case. And this, with regard to this, my lord, even that ground was not been taken in the trial also with regard to juvenile. What I have found it from the records,
is
I have shown it to the court.
They would have taken the plea at the.
No, it can be taken at
relevant
any
point
time,
in
my
time,
lord.
but
They can take it at any time,
Any
but
time,
they've
but
got to file an application.
So what I am on, if your lordship permits me, my lord, may I ask for a little bit of accommodation so that I can ask my clients, family members, for having a birth certificate or something like that,
No, that can always be taken care of at any time.
anytime. But so far with regard to the bail,
With
concern,
regard to 389, we'll dispose of these applications.
my lord, on 389 itself, my lord, second 389 will not lie.
No, second 389 will not write, but the juvenility issue will always be there.
No, that will
And
be
once-
trial unnecessary. The person will be behind the bar, my lord.
No,
So-
that will take time because
My lord, from
the records are here. Now that issue can always be taken care of any time. This 389 will dispose of on the basis of the records already there. That we are going to do. That we cannot keep it pending.
lord, just
We,
one
we,
way-
we also need some disposal, Mr. Council.
no, that I understand,
Otherwise,
my lord.
adjournment is there all along for everybody.
That I understand, my lord.
Ah,
Because
yeah.
of this particular thing, my lord, this record will never, whole record is impossible for a defense counsel. my lord.
We can observe in the order that this issue has been brought
Oh,
out.
my
but
lord,
unnecessary.
My lord,
That-
with regard to substantive evidence also, on the basis of which he has been convicted. My reading of the evidence, my lord, doesn't make out a case wherein he's been part of the particular part and parcel of the particular unlawful assembly, my lord.
But his name has been specifically mentioned
My
by
lord,
the witnesses.
naming, my lord, the law with regard to 149 was this, my lord, that firstly, that assembly has to be an unlawful assembly. And if he is in part of the unlawful assembly, then he comes in Roman without any specific overtake. Now the law has changed, my lord. With regard to that, my lord, out of curiosity, a person runs to the place of occurrence, he cannot be roped in. Some specific overtake has to be attributed. Whereas here in this case, there is none, my lord. There is nothing. That's why I am pressing for bail, my lord, for this particular person. And my lord will kindly see. In the evidence, Hassan Ali, name has been taken. Who is the Hassan Ali? Mondal or this? That is not been cleared from the evidence, my lord. And from there itself, I get benefit of doubt. As your lordship from the Sarshid said, there is Hassan Ali and Hassan Ali Mondal. One and same person. Now, from the evidence, who is that Hassan Ali? That has been missing. And if that is so, then I get the benefit of doubt, my lord. Why I should be behind the bar? And if your lordship go through the evidence of PW5, which according to the prosecution, my lord, is an eyewitness. Now, so far Hassan Ali is concerned, my lord, he make a statement. The person who followed Jahar Ali, who is the deceased, and Suleiman, when Jahar Ali reached, the other accused person, Hassan Ali, Jamal Ali, Suleiman Ali, etc., had assaulted and hit the victim by sharp weapons. As a result of such assault and hitting of by sharp weapon, the victim Jahar Ali breathed his last. This is the specific, my lord, statement made on oath. Now, whether this statement has been in the previous statement, absolutely no. If your lordship goes to the evidence of the IO's evidence, one by one, I take your lordship, and he's been brought from jail, my lord. He's a criminal.
So what do you mean to say? That a criminal, that a,
Falsely implication, there is every chances of false implications, and it is false implications because of the fact that it is absent in his previous statement. Yeah.
PW 5 and 6 brought from jail. Huh?
Yes, yes. So we are not looking into that particular evidence, my lord, because of that count. And these two persons witness will kindly see, my lord. At the time of occurrence, they were 3 persons. And these 2 persons kept mum for 2 days, my lord, and thereafter FIR has been lost against whole of the family members of this particular case. 2 persons, if they are eyewitness, my lord, what is the distance between the police station and the place of occurrence? It's in the market. They did not report to the police. This aspect has to be appreciated, my lord. And next, my lord, apart from this one, 5 and 6, 8, my lord. According to the prosecution, my lord, Manwara, my lord, 8, Khatun. Manwara Khatun not even whispered my name. She is an eyewitness. She didn't see me. So the falsehood of PW5 is been, my lord, been demolished by PW8 itself. A place of occurrence, my lord, it's a part high. Everyone is who is present, who is not, is been seen. Now, why I'm saying so that they are, my lord, inimical to me. And it's from the bird high, my lord, PW8 being an eyewitness didn't even whisper my name.
Lordship in P.
And PW11, they are saying, my lord, is an eyewitness. I'm sorry, my lord. PW11 that didn't even whisper my name.
PW6 also Lordship, in PW6, he was also eyewitness Lordship. He was coming towards his home from supper market. While coming, he heard hue and cry near the house of Makbul Hussain. He saw victim Johar Ali was running and he was followed by accused Syed Ali, Habib Jamal, Makbul Hussain, Hassan Ali, Akhir Ali, who is the father of Hassan Ali.
Following me.
So
And the
there
specific
is something,
overtake-
Lordship, that
No, my lord. Let us be clear, my lord. I am following someone. Does it amounts to a committing a criminal offense? Because later part of the statement, my lord will kindly appreciate. I am not reading the half truth. I am putting the whole truth before the court. Heck, minute. The person who followed Johar Ali caught hold of in front of my house and thereafter accused person started beating the victim Johar Ali. Accused Syed Ali had assaulted Johar Ali by a dao. Habib also struck Johar Ali by a knife. The other accused person assaulted the omnibus statement. So the specific overtake attributed to 2 persons only with regard to causing of the injuries. And 10 persons are behind the bar. And if 5 and 6 are the eyewitnesses, my lord, and 6 kept mum for 2 days, didn't even whisper to his neighbors, didn't react. And as per 161 statement, the whole incident took place substantively in the bazaar. In public, my lord, before the public at large. And PW8 didn't even implicate me. PW11 didn't even implicate me. Not even named by me, my lord. In this context, my lord, on the factual background of this case, my lord, the personal liberty of a person, my lord, he is all along been in bail during the trial, never evaded the process of the court. Subject to correction, my lord, subject to the judgment delivered by this honorable court. Why he should be behind the bar, my lord? Only because a judgment has been passed before against him, my lord. Wherein, with regard to the shortcomings in the judgment, my lord, I have put it before this honorable court. Under these circumstances with folded hands, my lord, I would pray, my lord. Let him come out, my lord, with whatever conditions, my lord. Every day he has to go to the police station, he will go, my lord. He's not a criminal, my lord.
That's all
That's all, my lord.
for Hassan Ali.
Hassan Ali.
Yes.
Lordship, there is eyewitness and everyone is saying Lordship. So at this stage, Lordship, we cannot be granted Lordship.
Okay, now that is for item three.
Three.
Now item four, Akhir Ali.
Yes, I got. So for Akhir Ali is concerned, my lord, he happens to be the father. He happens to be 72 years old, my lord. At the time when 313 statements were recorded, my lord. Now, with regard to this, my lord, the informant, my lord, did not even name. He's been a family member, my lord. FI consortium. FI consortium. Whether he's been named. In the substantive evidence, my lord, Habibur, Sayanso, Jamal, and Sahar Ali to kill my brother. When Jahar Ali tried to escape from the accused, Hassan Ali and Akhir caught him. This is much is the evidence, my lord. And so far, my lord, PW1 itself is not an eyewitness. At the place of at the time of occurrence, he was in Goalpara. That has come during cross-examination. And so far, PW5 is concerned, my lord. So far, assault part, my lord, this particular accused person is not been named by PW5. And PW5 who has been brought from jail, my lord, and the persons whose name has been given in substantive evidence was not before the police. It was in the first time in the court. It has no evidentiary value so far with regard to a case wherein 302, where the life of a person is involved. Quality of evidence is required, not the quantity, my lord. So far PW6 is concerned, my lord, he named father and son, both of them, my lord. So far specific act is concerned, my lord, with regard to beating and causing, my lord, giving a knife blow, that is with regard to Jahar Ali, one Jahar Ali, my lord, co-accused. Habi also struck Jahar Ali by a victim. Now, who was that particular person, my lord, with regard to this? And this particular person, my lord, witness kept 2 days mum being an eyewitness. That itself create doubts, at least in my mind, that my family member is killed and I know the culprits who have caused the murder, and I keep mum, not even shared with my neighbors. And he happens to be saying that the place of occurrence is a market, whereas the place of occurrence is somewhere else in a, my lord, paddy field. And so far with regard to PW8 is concerned, my lord, not even whispered my name. So far PW11 is concerned, my lord, I went out, I saw Johar Ali was running, and all accused persons say omnibus statement, all running behind. And hit Johar Ali by dagger. So he's one of the deceased, my lord. So far with regard to specific overtake, absolutely nothing. PW11 is concerned, my lord. Absolutely nothing. Only statement with regard to this particular witness is concerned, I am running behind. That's all, my lord. With regard to this 72 years old man, I would pray, my lord, that they have, my lord, from the downtrodden people, my lord, day-to-day earners and all such things, my lord. And he has been facing the trial all along, never misuses liberty, man. Never misuses liberty. Submitted to the court for justice, my lord. And it's a fact on the record, judgment has come against them, my lord. And I am appreciating the materials on record, my lord, wherein, my lord, 302 by 149 and the sections of law, my lord, that I am part of this. And if commotion take place, everyone runs to it in these areas, my lord. Even in Guwahati, my lord, what happened, what happened? All person can be roped in that way, that manner. 149 is dangerous proposition. And that's why the law, my lord, as on today, my lord, even some role with regard to specific overtake has to be attributed, my lord. And so far 148, 302 for life, my lord. 201 by 149, there is no evidence that tamper with the materials, evidence. There is no material.
No evidence with regard to 10.
No evidence with regard to 147, my lord. 145 is unlawful assembly. There is no evidence that there has been an object to kill this particular person with this object. This object has not been proved in this case. No evidence, whisper of evidence. And in pursuance to the objective of killing this person, they went all along. No, two persons were there going, my lord, and some persons were seizing and they were following them. That's all is the evidence. In this factual matrix, wherein two eyewitnesses, 8 and 11, as per the prosecution, my lord, don't even whisper my name with regard to, not to talk about specific overtake, not even with regard to, my lord, my presence in the place of occurrence. No, my lord. It cannot be as such, my lord. Suppose an occurrence has been happening out here. We are all sitting. Different versions will come with regard to minor materials. So far with regard to presence and specific overtake, there cannot be two ways. There will be one way. But here, 8 and 11, prosecution witnesses, my lord, not even whisper my name. Not even whisper my son's name. And so far son's name is concerned, my lord, I am appreciating again, my lord, and putting it before the court, that who is that particular Hassan Ali? That has to be specifically on evidence on record. Because if it is two Hassan Ali has been implicated, one has died, who was that Hassan Ali? There is nothing. In these circumstances, my lord, considering the age, I would submit, my lord, to this honorable court with all my immunity, my lord. Let him come out, my lord, on bail on strict conditions, my lord. He will follow, my lord. General principle is that, my lord, prima facie, if I can submit before this honorable court, satisfied to that extent, that yes, it may be a case of interference, then, my lord, may release them on bail, my lord. If at all they are convicted, they will go back to this, my lord. And they have submitted all along. They were all along in bail, my lord. They faced the trial. This is my respectful submission.
What about item 6?
6, I am not there. 3 and 4, I am there.
Yeah, 3 and 4.
Yes.
No one had asked item 6.
Can you go back?
Lordship, regarding this also, Lordship, in PW6, Lordship,
Yeah.
they have stated his name, Lordship, Akhir Ali's name.
Yes, I told you. PW6
In PW6, that
son and daughter, both of them has been named.
and they have got hold of the victim, Lordship, then he was stabbed, Lordship.
No, that's an omnibus statement. The statement is like this, my lord, I'm reading. The person who followed Zahar Ali got hold in front of my house. Thereafter, the accused person started beating the Zahar Ali. That is the statement, my lord, omnibus statement. Then, my lord, accused Habi also struck victim Zahar Ali with a knife. That accused person assaulted Zahar Ali. As a result of beating and hitting the victim, Zahar Ali succumbed to his injuries on the spot. I saw the entire incident of so and so. He has also been brought from jail. And he's kept quiet for 2 days. He didn't even talk to the neighbors. And even his place of occurrence, according to him, is the market. Whereas as per the prosecution case, it is in the paddy field.
Item 6. Six objection filed was on this. Item 6. Like on.
May I please, your lordship, let item, for the item 6, let prosecution file the objection.
Oh, there's no final objection.
Lordship,
In both are objection.
আবার আমার সাইকেলে হ্যাঁ নাই করা করা নাই না নাই করা
So you are in 3-4.
3-4.
Mirajul Haq, no? Objection 4 weeks. Objection file করা নেই Lordship, maybe as Jahan has taken, but she have that file, so I will file.
Miss
A Begum.
A Begum is granted 4 weeks time to file written objection. Item
Lord.
6. All these matters are going to be listed tomorrow anyway, because that item 1 and 2. 1 to 6 will be listed tomorrow. Uh, uh, um, so it's, however, as all the matters are tagged together, list the matter. Oh, anyway, so yes, what have you got to say with regard to this?
Lordship, not that this
Same
stage,
thing.
Lordship.
Okay. Heard Mr. A.K. Bhuya, learned counsel for the applicant appearance in IA criminal 675/2023 arising out of criminal appeal in criminal appeal 286/2023 and in IA criminal 679/2023 in criminal appeal 288/2023. Miss
A Begum.
A Begum appears for the respondent, state learned APP appears for the respondent. Out here also, we'll pass the order later. We'll decide. Pass the order, then we'll say, in the main case, list the matter tomorrow. 1 to 6 will all will be tomorrow, right? Right. He'll come tomorrow. All the cases will come tomorrow.
Publish. This will work.
Give us this, give me this item 3. Huh? Three, no, 3 is enough. The file only 3 is enough. No, I will dispose it of it. That 1 and 2, no? They have already filed a written objection.
Lordship.
So we will dispose of those 389. Yes, item 18. Who is the council? Yes, where is the written objection? Item 18.
Paper books to the other. Minor missing order.
Miss S.H. Bora, learned APP is granted 3 weeks time for filing written objection. This was on 13 December 2023.
Lordship. Lordship, just after Bihu, Lordship.
Give me the main file. let us see the- This is a amicus case of an amicus of what?
No, Lordship. One P.
Mr. P.
Sharma.
Sharma and
Yes.
P. Sonowal.
Yes.
You're right. No one appears for the applicant appellant. Full stop. No written objection has been filed by the learned people. Despite the earlier order passed by this. It is also noticed that paper book is present, has been made. Accordingly, leave this matter for hearing in usual course. In the meantime, the additional PP may file affidavit in opposition, written objection.
Lordship. Highly
So we'll dispose of the entire thing. No
Lordship.
point waiting.
Lordship. Any date has been fixed for filing objection, okay?
We said within 2 weeks.
2 weeks. Organized.
We-
Wait, please, your lordship. Lordship, in this case, lordship, I have completed my argument part, lordship. Then last day, lordship has directed me to file lordship written argument in precise manner, lordship. That I have prepared, lordship. Now their prosecution side, they have to file that. Today I have come up with this which lordship written argument, lordship.
Let's submit for consent. She has made, she is there. Please submit.
My part is over, lordship. Only that written argument.
No, we'll have to find out again. We don't remember what has been done.
Yes, lordship, this is the case, lordship, what happened, lordship, one person has hired the vehicle, auto rickshaw from Future Medical College to Dhulai, lordship.
Ah.
In the meantime, lordship, that person was killed, lordship, out of 4-person, lordship, 2-person escaped, lordship, when that present appellant, lordship, he came to sell out this auto rickshaw. But, lordship, that 2-person who were before this court, lordship, they were not, lordship, actually committed that offense. So far, lordship, there is no direct evidence against them, lordship. The case was based on circumstantial evidence, and moreover, the lordship evidence on the history sheeted, lordship, on his version, lordship, the conviction has been made, lord. That is the case, lordship.
Now, what is to be done?
Lordship, Bhuya is there, Lordship. She have written the written agreement is.
Hard part is remained.
She's, have made it, Lordship.
I am acting on behalf of informant, on behalf of Ella Mazumdar. My response submission is that there is no information in the judgment passed by the learned court. Your lordship, maybe after the judgment of the court.
Very easy way out. That's all.
We have prepared, orderly, we have prepared, Lordship, the written agreement.
So what is to be done now? Where is Miss Bhuya? Where is your written argument?
Yes,
sir.
sir.
You give it same time because she's not here. Right, Mr. B. Chowdhury, Leonard Counsel for the appearance, submit that the written argument is ready. As Ms. B. Buyan, additional PP is not present. The issue of whether written argument has been prepared by the prosecution. Would have to be clarified by the next day. From Mr.
Islam on behalf of LR Mazumdar.
Islam on behalf of Mr. L.R. Mazumdar, not ask for the informant, submit that. He will not be filing any written argument. And his only submission is that the impugned judgment should be upheld.
Lordship, may I submit lordship on behalf of the Bhuya lordship. Says in court now, another court lordship. His lordship, this matter may be passed over for the day only lordship.
This is
Otherwise,
a
he's
matter
present.
after the vacation.
Lordship, can it be after first week of February, Lordship? Probably.
This is a matter in the first week of February.
Yes, Lord.
Unauthorized.
Obliged.
60.
No point.
There's no one here.
But is a, although appeal Manoj, we have bail. Appeal. Bail matters.
So what to do?
We are respondent Manoj.
I know. So no one appears for the apparent.
Your Honor, my simile is just on the.
Yeah, I see.
Sir.
He wanted adjournment in some case. Item 11. Some case he doesn't want adjournment. Yes, Mr. Kamal, you are ready for item for 2023 matter.
Well, this is not, though it's nomenclature, there's criminal appeal, it's basically a bail application, my lord.
But then this item to 2017 matter, item 11, you have asked for adjournment.
Yes, yes, because I have. to
On
prepare-
5 occasions also you have asked for
Yeah,
adjournment.
That's true, my.
Then?
Well, actually,
Not
this,
fair.
no, it's fair because of the fact, my lord, that these matters are pending for bail hearing for pretty long time, my lord.
No, but
That
that
person is
appeal has
engaged,
been,
my lord, we'll do it, my lord.
appeal has been pending for the last
Yes, yes, absolutely.
7
Actually,
years.
I have been recently engaged thereof. But in this case, actually, since I have to prepare the length, my lord. So either of it, I have to prepare and come by.
But then you have been adjourning that,
Yes, absolutely.
criminal matter appeal.
True, my lord.
I think you should,
I-
you should have attempted to.
I'll do it
dispose-
tomorrow, then we shall not.
Tomorrow, no, we've already passed the order, not for.
Acha.
I mean,
But I prepared these two.
No, no,
because
it's
we have to
okay.
give A healthy
You,
time. my lord.
you prepare whatever. But then you have been asking for adjournments time and again in item 11. This is not fair to your client.
Sure, man. We can, sometimes we can't make a balance, man, that become in.
Yes.
So, my lord, this criminal appeal is directed against the impugned order of bail rejection, my lord, which is at page, my lord. 66, my lord. Before going to that, my lord, if we know the allegation, I think it will be better proposition, my lord. That is an occurrence took place on 15/5/2019, my lord. And I have been arraigned as accused number 5 in an ongoing trial, my lord.
The relevant allegation is page 54, para 17.23.
Page 54.
Yes. Para 17.23 of the charge sheet, my lord. What is the allegation against me, my lord, and what are the charges level and what are the charges frame? I'll come to it. Evidence against Indra Mohan Bora, A5, the accused appellant before your lordship. Role and involvement of accused Indra Mohan Bora, A5. The role and involvement of accused Mohan Bora has emerged during the course of investigation as one of the activists of United Liberation Front of Assam. So I am considered as an activist. The accused is an active supporter and activist of Alpha and is maintaining links with cadre of Alpha, which is a proscribed terrorist organization. Alpha Independent is carrying out submersive and anti-national activities, including terrorist act. He has provided logistic support to the cadres of the Alpha I by providing transportation and shelter to Alpha I cadre. He is associated with conspiracy to achieve the goals of the Alpha Independent with other co-equal. But not a whisper to death to whom I save and accept the accused number one of this case. So just omnibus statements made for the purpose of the case. During investigation, it came to light that the accused Indra Mohan Bora A5 used to contact with other members of Alpha using phone calls, Facebook, such and such. So here I'll pause and submit, my lord. No CDR of this person has been given, my lord, save and accept with that A1, my lord. During investigation, it came to light that accused Indra Mohan Bora tried to conceal his mobile phone, pen drive, and memory card, mass storage device. These items were recovered from the house of A5 after he left. So on the top, my lord, they said that I have concealed, so I was not giving to them. And in the other hand, under section 27, so this discovery is made on my showing or whatever so much. These items were recovered from the house of A5 after he led the police party to the spot where he had these items. These items were recovered in presence of independent witnesses. The statement of the seizure witnesses and the seizure list will prove that A5 had tried to hide incriminating materials. So what are these incriminating materials is not stated. The analysis of CDR of the mobile number, such and such number used by accused Indra Mohan Bora confirmed the conspiracy. On the revelation made by the accused Indra Mohan Bora, the CDR of the mobile number used by Indra Mohan Bora was collected from the concerned service provider. It was studied there and it was found that accused was in telephonic contact with accused Papu Coach, Bokolia, Vijay, Oham, Anvi, aliases Rajini. So this is the only incriminating material coming because
Who is this Papu Coach?
but he is the main accused of this case who lobbed the hand grenade in a shopping mall, my lord. And no person died, but of course injuries were caused. Accused Indra Mohan Bora A5 were using the phone number such and such and such and such. He used the said mobile to contact with accused Papu Coach Bokolia between the period from 25/18 to 18/5/19 and 16/5/18 to 16/5/19. So, my lord, if your lordship will see the date, my lord, probably there's a typing mistake. Between the period from 24/5 to 18/5/19, probably 1 year. Then again 16/5 to 16/5/18 to 16/5/19 respectively. But no such CDR, as I am told by the trial court conducting lawyer, of 2 years has not been given to them. Then customer application form
of mobile phone number such received from the concerned service provider established that the subscriber of the said number was Radhakanto Bora, son of L.R. Bora, village Sosali, Biragaon, district New York, but investigation established that the said number was used by Indra Mohan Bora. So the mobiles belong to somebody else. Then another customer application form of mobile number 31 received from the concerned service provider established that the subscriber said number was Indra Mohan Bora alias Papu, son of Rebokanto Bora, such and such. Tower location of accused Papu Post Bokolia of Vijay Anvi on 26/4/2019 and 16/5/19 was in Nagaon. Your Lordship will kindly take note of my submission, my lord, when I will submit after reading this. Was in Nagaon where the house of Indra Mohan Bora is located, which indicates that he was Indra Mohan Bora on 16/5. Now, my lord, I'll submit here, my lord, that this is not a correct statement of fact, my lord. Your Lordship will see Nagaon. Nagaon is a second largest or third largest town of the northeast, my lord. So in Nagaon, it is a vast area. And I happen to be a resident of Samuguri and not of Nagaon, my lord. Only they are saying that the tower location was in Nagaon. Now suppose somebody is in Guwahati, my lord, whether I am in Guwahati University, whether I am Guwahati Medical College, or whether I am in the Guwahati High Court, my lord, nobody knows.
Their addresses of?
Or Samuguri, my lord. Original place of stay, my lord. Puroni Gudam, I have written, my lord. Son of Rebokanto Bora, resident of village Sosali, Puroni Gudam, under Samuguri police station in the district of Nagaon. District Nagaon and town Nagaon is the different thing, my lord.
The Samuguri is Nagaon district.
Yeah, absolutely. Under Nagaon district. Located indicate it was Mohan Bora on 16/5. Then the connectivity chart of accused Indra Mohan Bora with accused Papu Koch. Scrutiny of the extract data from CRT in the mobile phone and memory card recovered of the leading Indra Mohan Bora established the fact that these digital devices were used by the accused Indra Mohan Bora. Indian also established that association accused 1 with accused Indra Mohan Bora A5. So this is the only allegation. Within the small periphery, it revolves, my lord, that I had connection with A1. I'd like to furnish a list of dates and the other sections for your lordship. Time continues. You can start. Ma'am, Madam.
No copy for your friends.
My lord, that's the problem, my lord. They know, my lord, it's on the record for your lordship convenience.
So that we are all on the same page.
Oh, yeah. No, I'm just giving it for your lordship convenience to understand the links, my lord. I've earmarked it also, page limited, it, my lord. I'll give it, my lord.
Yes.
My lord, if you turn your lordship to page 3, my lord.
Yes.
My lord, these are the sections under which charge sheet has been filed against the present accused, my lord. I have made a chart, my lord, showing the sections and the definition of the offense along with the punishment. So this is the charge sheet was submitted against 5 sections. 120B, punishment for criminal conspiracy, wherein the punishment is death or life imprisonment or RI for a term of 2 years or upward. So it runs from 2 years to life or to death, my lord. Then 18A UAP, punishment for conspiracy, not less than 5 years, but may extend to RI for life. Punishment for harboring, not less than 3 years, but may extend to RI for life. Offense relating to membership of a terrorist organization, not exceeding 10 years. Offense relating to support given to a terrorist organization, not exceeding 10 years. So the maximum punishment here will be, my lord, that it will be of 10 years, my lord. Because ultimately, if your lordship will now turn to kindly page 4, my lord, we'll see that 120B, there is no charge now. So these are the four sections wherein I have been now charged and I am facing trial, my lord, at page 4, that is 18 UAPA. So these are the four sections by which I am facing the trial. So in this case, the alleged incident took place on 15/5/2019. Next page, if your lordship will see the list of date. It was originally registered as Gitanagar PS, FIR number 210 of 19, 16/5/2019. Then 18/5/2019, Gitanagar PS arrested the accused appellant Indra Mohan Bora. On 18/5, I was arrested. Then on 26/5/2019, the NIA took up the matter and raised the new case as RC4. On 11/11/2019, madam, the charge sheet was filed by NIA against 10 accused persons, showing 2 persons as absconded. And the accused appellant Indra Mohan Bora was arraigned as accused number 5. And the rule that transpires, my lord, is at para 17.23. Then on 8/6, my lord, the impugned bail order which I challenge is now before your lordship, my lord, is also there, my lord. Then in the meantime, on 10/3/21, my lord, the co-accused Amrit Vallabh Goswami, A6, was granted bail, who is also similarly placed. In fact, I am more better placed than Amrit Vallabh Goswami, my lord, who was granted bail by our Honorable High Court. Then on 3/2, my lord, the charges were framed, my lord, as I have read it out.
How many witnesses?
Only 17 witnesses have been examined as on today, my lord. And there are 20. So latest I may not be ever. Last time it was 17 when I was prepared. By this time, maybe 3 more have been 20.
So it's in the faggot.
No, it's in the beginning end. It's in the beginning stage, my lord. 177 witnesses are to be.
177.
Yes.
Oh, 177.
And how many documents I'll give your lordship, my lord? 177 PWs has been cited and only 20 has been examined as on date, my lord. And documents are 237 documents they will be examining it. And I am behind the bars for 4 years, 7 months, 22 days. So if we calculate the date, my lord, it will be 1,672 days.
1,672.
Or 1,672 days. And year-wise, it is 4 years, 7 months, 22 days. As on date, kindly verify, huh? One or 2 days maybe here and there. 4 years, 7 months, 22 days, my lord. So my only allegation against me is that I was in contact with Papu, but what I did, what I noticed is nothing. He is a veteran alpha, and he is one of these kids. He is the person who locked the granite. So reading of the allegation narrated in the charge sheet,
When was the grenade locked?
on 18/5, my lord. This was it. On 15/5/2019, my lord. The day of occurrence. And immediately after 3 days, I was arrested by the local police on 18/5. So, my lord, coming to the impugned order, my lord, which I have assailed here, my lord, is at page 66. Because on 2 grounds it has been rejected. That earlier it was rejected, so I cannot review my order, one way of saying in this order. And the second is that the London Trial Court is not a constitutional court. So the judgment relied upon says that it is only the constitutional court to grant bail on the ground of violation of part 3 of the constitution. That page 68, my lord. I'll show it your lordship. Let's start from page 66, my lord. This is an application under 437 CRPC praying for grant of bail to accused Indra Mohan Bora
in special case number 2 of 2019 under section 120B, read with section 18, 1939 of the UAP Act. Probably this also the court went wrong, my lord. Because 120B was not in the charge, because this was framed after framing of charge, my lord.
It says here 18, 1939 only.
Yes, my lord. But probably the honorable court missed 38, my lord. Because charge was framed much earlier, my lord. No, maybe. Yeah, charge. Because charges were framed on 3/2/22, my lord. 3/2/22 charge was framed, my lord. So I was facing the charge under the fourth section, 120B itself was dropped, my lord. So the trial court probably went on a wrong noting, my lord. This is an application under 437 CRPC praying for grant of bail to accused Indramon Bora in special case number 2 of 19 under section 120B IPC rate with section 18, 1930 of the UPI. The present accused Indramon Bora was arrested in this case on 18/5/2019, and since then he has been in custody. The investigating agency, after completing of the investigation, has submitted the charge sheet on 11/11/2019, wherein the present accused has been arraigned as a A5. Subsequently,
The
this court,
UAP Act.
Yes.
UAP Act. Yes.
subsequently, subsequently, this court has framed charge against the A5 under 18, 19, and 39, my lord. That record has to be need to be checked. Can you check the record? 38 is there only, because charge. For the time being. Oh, great. 38 is there. Fourth mistake. In the charge, 38 is there.
Yes.
So subsequent to the filing of the charge sheet, A5 had prepared a bail application being Mills case NIA number such, which was disposed of by order dated 6/4/20. So on 6/4/20, earlier my bail petition was disposed of and it was rejected. It was the second bail petition after framing of charge. A perusal of the aforesaid order dated 6/4/2020 would go to show that after elaborate discussion of the factual metric of the case, the material available on record, as well as the law laid down by the Honorable Apex Court and the Honorable High Court, this court has recorded its opinion on the basis of the material in the case diary and the charge sheet. There is a reasonable ground for believing that the accusation against the said accused person, that is A5, are prima facie true. As on the basis of the aforesaid opinion, this court has held that the bar under the proviso to section 43D5 of the UAP Act comes into play, and the special court is precluded from granting bail to the accused Indra Mohan Bora. So there is no absolute bar. This trial court proceeded on the assumption that 43D25, the absolute bar is there, my lord. From his passing of the order, it looks like that the trial court was of the view that since there is a bar under 43D5, So this court therefore at a subsequent stage of proceeding cannot come to a finding different from what it has already been recorded by the aforesaid order dated 6/4/2020 and go on to hold that the bar imposed by section 43D5 of the UAPA Act is not attracted in the case, my lord. My lord, as your lordship knows, my lord, the bail is always an interlocutory order. Once it is rejected, new ground shown and new facts emerges, my lord, then it can be taken up. Not that you stick to the ground where we
Is it
stand.
an interlocutory order?
My lord. So I'm just pointing out where the trial court might have done wrong, my lord. Because as your lordship knows, my lord, in a bail application, we don't challenge the bail order, my lord. The impugned orders are not made in bail applications, my
But here I find that there are challenges with,
lord. This is the only exceptional under the NIA Act section 21, my lord, that if you have to, you will have to make an appeal, my lord. So this is the impugned order at the outset.
so whether this bail order would be an interlocutory order. It will not
Yes,
be.
it's an interlocutory order, no doubt of it. There are many findings, if your lordship permit me, I'll please. In Ophir Gogoi's case, we have taken it, my lord. Court also agreed with. Supreme Court has said also. The bail are always otherwise second bail application will not lie, my lord. But of course, with the condition that you have to show the new ground.
No, but in this UAP Act,
Yes, my lord.
it's a.
Nothing is such, my lord. Nothing as such.
Now, should we just for a moment see section 21(1) of the NI?
21
One, my
And then I
Four.
will take the lordship to 21(4).
lord. Arohan Hassan is giving the photo. And I. First one is.
If I may just read out, lordship,
I will hold it.
section 21.
1 and 21(4).
21(1) reads, lordship, notwithstanding anything contained in the code, an appeal shall lie from any judgment, sentence, or order not being an interlocutory order of a special court to the High Court, both on facts and on law. And thereafter, if your lordship will come to subsection 4, notwithstanding anything contained in subsection 3 of section 378 of the code, an appeal shall lie to the High Court against an order of the special court granting or refusing.
Both ways. That is the only exceptional carved out under section 21 of the NIA. Raised the cases, my lord.
So this is an interlocutory order.
Yes. So that's why.
Bail order
Yes.
or the rejection of it.
That's why it has been made into appeal, my lord. That's why this provision of law has been incorporated. So here the judge again says, my lord, that this court therefore at a subsequent stage of the proceeding cannot come to a finding different from what it has already recorded by the aforesaid order dated 6/4/2020 and go on to hold that the bar imposed by section 43D5 of the UAP Act is not attractive. That portion is not tenable in the eye of law. Anything, I can file numerous application for bail, my lord. But of course, with a writer that you have to show some new ground. Suppose a bail application has been rejected, just to take a quick view, my lord. Your lordship says sitting singly in a bail application under 439 has rejected it.
tomorrow the person's father died, my lord. So on that special ground, it may be allowed for a limited period. It's not that it is static, my lord. So bail is just a provision, my lord. He is kept behind the bus to see that he is in attendance. So that the trial is not disrupted. Because the charge sheet was filed on time, so there was no default bail. My Furthermore, no new circumstance has been brought on record by the applicant to negate the earlier finding of this court as recorded in the aforesaid order leading to rejection of the bail pair. If at all the new subsequent subsistence that has arisen is that the court has framed charge against A5 by its order dated 3/2/22 under section 18, 19, 38 and 39 of the UAP Act. A circumstance that goes against the accused as far as the existence of a prima facie case against him is concerned. That is also wrong, my lord. Because at this stage, my lord, the only allegation of the prosecution has been taken into account, my lord. It is not that the case has been proved or has been established. Just one straw, one doubt also is good enough to frame charge against me.
No, but it says it qualifies that by saying prima facie case.
Yes, absolutely. At the time of framing charge, my lord, only prima facie material is available or not. Otherwise, there would have been no acquittal at all, my lord, if the charge is read as true.
No, so when it said that there is a prima facie case,
Yes, yes.
prima facie, there is something against you.
But absolutely. But the criminal jurisprudence runs on that belief, my lord, that it has to be proved beyond all reasonable doubt. That will be determined during the trial.
And
And-
be determined during the trial.
Absolutely. That is what I. Actually, basically, I am before your lordship on two counts, to be honest, madam. There's the length of detention. Trial is progressing at a snail pace, madam. So what is the necessity? And I am going to complete, say, 5 years very soon, madam. So in that event, what the Supreme Court says, what our High Court has said on this prolonged detention or incarceration, the pronunciation I may go wrong, incarceration. Huh? Incarceration, prolonged detention, my lord. So in that event, Honorable Supreme Court has time and again directed that you cannot curtail a right of a person by detaining him indefinitely till the end of the trial. Your lordship is aware?
But has it put a number of years that has to be put in?
Yes, absolutely.
5 years.
No, in one case it is 4 years, in one case it is 5 years. If your lordship permit me in the other item, my lord, which I will be placing it. He approached the High Court. 2 accused was taken up simultaneously, my lord, Sandeep's case, my lord. So in one case, it was rejected by saying that you come after 4 years. So at that time, when I filed a bail application, it was 3.5 years. So now 4 years, I'll place that judgment, my lord. It is already there in the other case, my lord. It's beautifully drafted, my lord, drafted by the Honorable High Court, my lord. It's a pleasure reading that judgment, my lord. I'll show your lordship when I'll come to that, my lord. Take a look. Sanjeev, okay, so. Hey, next item to demonstrate. Just I'll show your lordship, my lord. In this case, my lord, though it is reported, but I've written it. At page 112, if your lordship will kindly look into it, my lord. Everything in details has been submitted, my lord. Page 112. Let's start, yes, my lord.
How many pages?
My lord, it runs to some 100, no, inner pages will be, my lord, 50. But if your lordship will kindly turn to page 162, my lord. After taking all the judgments into consideration, my lord, para 91, my lord, page 162. In the present case, we have prima facie viewed that the appellant, that is Sanjeev's case, does not appear to be a hardcore under trial and his role is marginal in the bomb blast
incident on 15/5/2019, and as such, his bail can be considered even before completing 5 years of detention. If he has completed 4 years of detention, if there is no likelihood of trial being completed in the near future. Accordingly, we dismiss the bail application. We grant liberty to appellant Sanjeev Talukdar to approach this court, that is the High Court, again on completion of 4 years. So after 4 years, actually, I cannot come directly to the High Court, my lord, as your lordship has said, that in Nia case, we have to come in an appeal. So there must be an impugned order. So with this thing, armed with this thing, I approached the trial court and filed a bail petition that was rejected. And that has been now made an impugned order in this subsequent item, my lord, and I'm coming up after 4 years. My lord. That we'll have to dig. At para 94 also next page. Because there were 2 persons, one person was granted bail, that is Prakash Rajkumar. Then 94, your lordship will see, accordingly, criminal appeal 136 is allowed. Criminal appeal number 67, that is mine one of 2020 is however dismissed with liberty to the appellant Sanjeev Talukdar to approach this court again as observed earlier. So since I cannot come directly to this court, my lord, without any impugned order, so I approach the trial court. Trial court rejected on the same ground, which is now we are dealing with it, my lord.
Same ground meaning?
Meaning that already it has been rejected earlier and constitutional court can only grant bail on the length of detention. Your lordship will now find it. I'm at page 67, my lord. Mr. Nandi Learned Counsel for A5 has submitted that A5 has been in custody for nearly 4 years now and therefore deserves to be granted bail in view of the fact that only a few out of the total of 177 PWs have been examined and the possibility of early conclusion of trial is bleak. In this regard, the council submits that if the A5 is kept behind the bar throughout the course of the trial in view of the bar imposed by section 43 D5 of the UAP Act, his right under Article 21 of the Constitution of India would stand violated. In this regard, reliance has been placed on the decision of the Honorable Supreme Court in the Union of India versus K.A. Najib, AIR Online 2021 SC 13, wherein the Honorable Supreme Court has upheld the decision of the Honorable Kerala High Court granting bail to the accused, therein on the ground of incarceration of almost 5 years without the trial having started. So in our case, trial has started. Out of the 177 PWs, 20 has been examined. However, in the very same judgment, the Honorable Court has stated as follows. It is thus clear to us that the presence of statutory restriction in the section like 43 D5 of the UAP Act, Part C does not out the ability of constitutional courts to grant bail on ground of violation of Part 3 of the Constitution. So here I would like to submit, my lord, that this is not the spirit of the trial court while dealing with the bail application, my lord. Bail application, special statutory power has been conferred, my lord. Only the restriction and bar, as your lordship will be aware in an NDPS case, my lord, section 37 is the bar, my lord, that twin condition has to be satisfied, my lord. So this court say, the trial court said that since this Najib's case cannot be implicated, benefit can be given because that court is not a constitutional court. That it will not be a correct proposition. It is thus clear from the above that it is the exclusive preserve of the constitutional court, that is the High Court, to grant bail in a case of this nature, wherein the provision of section 43 D5 of the UAP Act is attracted, and therefore such a power cannot be exercised by the special court. That is my respectful submission for this. And this is how I assail the impugned order, my lord, by pointing out those wrong, according to me, has been found. Not going by.
No, but 43D.
Yes.
5.
Yes.
Provides for grant of bail.
Yes.
Only on the fulfilling of certain condition.
The main condition is not bail. prima facie the case is true. In any.
Not true.
Prima facie for them it is true, for me it is not true. Absolutely.
So it is, so therefore, for violation of part 3 of the Constitution, only the High Court and Supreme Court can pass a bail order.
That's not that.
Huh? So that is not your interpretation.
Never mind. With all respect, court has got its own power to grant bail or to refuse bail.
But then,
That-
this is, but then,
I'll
this,
show you, Lordship.
but then this is what the Supreme Court appears to have said. It is thus clear to us that the presence of statutory restrictions like so per se does not oust the ability of constitutional.
That
courts
is
to
the
grant
court's
bail.
finding, madam. This trial court, I will have to check it, madam, whether it is inside there or not, madam.
Let us see
Yeah.
this judgment, Supreme Court judgment.
I'll just read out, Lordship. That's
The Supreme Court judgment.
Yes.
Supreme Court judgment. That's Union of India versus K. Najib. Is reported in 2021 3 SCC 713.
Yes.
I've got the Lordship Manu Parada version.
Okay. Madam, I, okay.
Assembly.
Lagay ako.
Manu Patra version, Lordship, paragraph 18.
Para-
18.
First, read the first line, one or two
See,
para.
It starts with, it is thus clear to us.
Para 17 here.
Para first.
It is just after the paragraph referring to Zarur Ahmad Shah.
Yes, yes.
It is thus clear to us that the presence of statutory restrictions like section 43D5 of the UAPA per se does not oust the ability of constitutional courts to grant bail on the grounds of violation of Part 3 of the Constitution. Indeed, both the restrictions under the statute as well as the powers exercisable under the constitutional jurisdiction can be well harmonized. Whereas the commencement of the proceedings, at the commencement of the proceedings, courts are expected to appreciate the legislative policy against the grant of bail. But the rigors of such provision will melt down when there is no likelihood of trial being completed within a reasonable time, and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard the possibility of provisions like section so and so being used as a sole metric for denial of bail or for wholesale breach of constitutional rights.
If your lordship will kindly look into para 17 matter regarding how the Supreme Court dealt with 43D5. The lordship got it, madam, after Nia Zohur Ahmed Shah's 40 years. The point one.
Lordship, there is another case of Thawa Fasal versus
Awat Fasal, madam.
Union of India.
I'm relying on
Simply,
it. I have it.
that
So it's not the bully.
I think no,
Only one
I do
thing.
not,
Okay, you're taking us to this judgment.
yes, sir. Lordship,
What do you say about this delay in the completion of the trial, which is going to take a long time, it appears.
Lordship, yes, it has taken a long time, but then the punishment that has been indicated in the statute is Lordship life. So, what would be a long period for a life sentence.
And supposing he is acquitted, then what happens?
That lordship, I do not see any possibility of, because
Don't be a judge. The court is asking what happened. As a lawyer,
I,
Huh? Special? No, that is there.
Also, you are submitting in future.
No, but what happens, if the trial takes 10 years, or 15 years, or 8 years, and he is acquitted? Which could happen. Then what happens?
it could happen.
That way, madam, with your lordship permission, madam, just appointing your whether 436A half the sentence, now it has been made into 1/3, madam. The new record.
Anyway, let
Yes,
us
madam.
see.
But I'm just pointing it out, your lordship.
No, we're going to get Fasal, that case.
Lordship, that paragraph 38 of this,
38.
38, Manukatla, lordship. I'm just reading out, as held in the case of K. Najib, the stringent restrictions imposed by subsection 5 of section 43D do not negate the power of the Constitutional Court to grant bail, keeping in mind violation of Part 3 of the Constitution. It is not disputed that the accused number 1 is taking treatment for a psychological disorder. The accused number 1 is a student of law. Moreover, 92 witnesses have been cited by the prosecution. Even assuming that some of the witnesses may be dropped at the time of the trial, there is no possibility of trial being concluded in a reasonable time, as even charges have not been framed. There is no minimum punishment prescribed for the offences under Section 38 and 39 of the 1967 Act, and the punishment can extend to 10 years or only fine or with both. Hence, depending upon the evidence on record and after consideration of relevant factors, the accused can be let off even on fine. As regards the offense under Section 13 alleged against accused number 2, the maximum punishment is of 5 years or with fine or with both. The accused number 2 has been in custody for 570 days. Next panel, lordship. It is true that without recording a satisfaction as contemplated in the subsection 5 of section 43D, the order granting bail of the accused would not have been confirmed by the High Court. However, we have examined the material against both the accused in the context of subsection 5 of section 43. Taking the materials forming part of the charge sheet as it is, the accusations against both the accused of the commission of the offense punishable under section 38 and 39 does not appear to be prima facie true. Here is a case, lordship, where prima facie materials were not there. Therefore, in view of the findings which we have recorded about, the appeal preferred by the accused is allowed. The impugned judgment and order of the so that has been allowed. Now, lordship will have to be satisfied whether some materials exist or not. Under, if lordship there are prima facie materials, and that lordship will see the wordings in section 43 B5 proviso. I'm reading the whole 43 B5. Notwithstanding anything contained in the code, no person accused of an offense punishable under chapters 4 and 6 of this Act shall, if in custody, be released on bail or on his own bond, unless the public prosecutor has been given an opportunity on the application for such release, provided that such accused person shall not be released on bail or on his own bond if the court on perusal of the case diary. Lordship, you see, if the court on perusal of the case diary, the perusal of the case diary may be a situation where the report under 173 has not been filed. Or, it says or, the report under section 173 or the report under 173 will indicate that the charge sheet has been filed. So, once the charge sheet has been filed, Lordship, the honorable court will look into the charge sheet. Because it says explicitly, all the report made under section 173 of the court is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Now, in the course of the trial, Lordship, as it is 20 witnesses have been examined, whatever comes up, it may go against me, it may be against him. But that is a call which the trial court has to. So far as Lordship releasing him on bail at this stage, in my humble submission, if there are materials, Lordship, in the charge sheet, perhaps that would be enough.
Well, I'm just making a submission to his submission, my lord. If my counterpart submission is to be upheld, my lord, then the High Court's hand will be tied, Supreme Court hand will be tied, my lord. It is only the trial court who can grant bail. That is not the proposition, neither does the legislation, my lord. If I can show, my lord, that 43D went to be accepted, because here in this case, so for this accused person is concerned, my lord, he has not played any submersive activities, neither he has taken participation in any of the boom blast, neither any arms were recovered. My only allegation is that I had a link with A1 who lobbed the grenade. That much so. Neither I was.
You had a
I had a phone call with him, my lord. Phone call connection.
numerous phone calls.
Yes, that is the only allegation, my lord.
33
Yes, my lord, absolutely. No doubt of it, my lord. Others who had 166 phone calls, my lord, has already been released on bail, my lord. Amrit Ballabh Bora, I'm showing it. It is reported, my lord. With Amrit Ballabh. My lord, I have also prepared it. 2021 to GLT 751. And the other one is that Rajguru's case, my lord, which I am already relying it on Sanjeev's case, my lord. The judgment passed by the Honorable High Court, my lord, which I have already placed it by on the other matter. Probably that is not reported, that's why.
When did you give it?
But I just now, all of it, I got ready to give. I got to do. Sanjeev.
They have got only this two, only these two. Only two have been given.
But I have referred it page 112 or something like that, my lord. This is it starts from page 112, my lord. I'm relying on this, my lord. In this case, there were
112 of which?
my lord, the other one, item number 17, my lord, criminal appeal 340. In this case, my lord, at page 112, two accused appellants were before the Honorable High Court. One is Sanjeev Talukdar, and if your lordship will turn to next page, my lord, that is Prakash Rajkumar, alias Chu Nam Talo. This person, Prakash Rajkumar, was granted bail, my lord. And so far, my accused was concerned, Sanjeev Talukdar was not granted bail, but given a direction to approach the Honorable High Court after completion of the 4 years period, my lord. After completion of 4 years, my lord, I approached the trial court, and thereafter now I am before your lordship. So these are the two judgments, my lord. So, my lord, just coming to the case of K. Najib's case, my lord. What the Supreme Court say regarding 45(3) to 5, my lord. Para 18, after my lord, the para may differ, there's a
Para 18 now?
para 17 of Najib's case, my lord. Union of India versus K.A. Najib, my lord.
Yes.
just after the para, as regards to the judgment of Nia versus Zohur Ahmed Shah Watalia, down below, it is thus clear to us that the presence of the statutory restriction like section 43D5 of UPA per se not oust the ability of the constitutional courts to bail grounds on the violation of part 3 of the constitution. Indeed, both the restriction under a statute as well as the power exercisable by the constitutional jurisdiction can be well harmonized. Whereas at the commencement of the proceeding, the courts are expected to appreciate the legislative policy against the grant of bail. But the rigor of such provision will melt down where there is no likelihood of the trying bill completed within a reasonable time and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard against the possibility of the provisions like section 43D5 of the UAPA being used as the sole metric for denial of bail or the wholesale breach of a constitutional right of a speedy trial. So now, while skipping the next para, my lord, and coming to para 19, my lord, before that, starting one, I'll say, NDPS Act is more stringent because here the consideration is prima facie true, and out there, my lord, that he is not guilty of the offense. In section 37, the restriction is not guilty of the offense. Here, whether the case is prima facie true. That has been dealt with at para 19 of this case, my lord. Just if your lordship will read, I just take a few minutes. Yet another reason which persuaded us to enlarge the respondent accused on bail is that section 43D5 of the UFA is comparatively less stringent than section 37 of the NDPS Act. Unlike the NDPS Act, where the competent court needs to be certified that prima facie the accused is not guilty and that he is unlikely to commit another offense while on bail. There is no such precondition under the UAPA. Instead, section 43D of the UAPA mainly provides another possible ground for the competent court to refute. In addition to the well-settled consideration like gravity of offense, possibility of tampering with evidence, influencing of witness, or chance of accused evading trial or absconding bail. So when his courts are granting bail under the NDPS Act also, which is the most stringent by UAPA is not that stringent, incompatible with section 37 because section 37 says minor UAPA. Because section 43(9) will your lordship will see 43D5 minor. Both of them.
Yes, basically, when there are reasonable grounds for believing
Yes, my lord.
that the accusation against such person is prima facie true.
True, absolutely. That is the consideration while dealing with a bail petition and the UPA. Has been given an opportunity provided such accused be released on bail on his own if the court on the case.
No, now you see, the issue is this.
Yeah.
Basically, at best, what it appears is okay. Supposing he is part of that organization. Now, what is the penalty for being a part of that organization? That is one aspect we have got to look at. Now, the other aspect is, if he is a part of that organization and if he committed the act or acted in furtherance of the, blasting the grenade with the help of A1, that is another provision. So now, as per what is reflected in the petition, what prima facie appears to be is we have to first connect that person, the applicant, with the organization. So that okay, maybe the call records, supposing we accept it, even with or without CDR, whatever. Now the second aspect is whether he acted or was a part of that bomb blast. That part we'll have to see. So then let us see the ingredients of the provisions that have been, that have been framed, the charges framed against.
Yes.
First of all, when was the charge sheet filed?
Well, I have given the date, my lord. In my typed copy, your lordship will get everything, my lord.
Eleven, 19.
On
11/11/92. 11/11/92.
Charge sheet
Now, let us see what is 18, what does it say? 18
is applicable, lord.
18 is punishment for conspiracy. Now, for punishment for conspiracy to take place, following a person continuously for a certain period of time could be due to many reasons, could be some other activity. Can we say that it can be confined or it points only towards that grenade blast?
Well, I
Or
know
would it be to some, maybe some gun firing taking place in some other area of the state or something, I don't know. That is one. Number two is punishment for harboring.
Yes.
Now, where is the harboring aspect in the case? That I've not been able to make out. I mean, from the limited.
From the charge sheet narration.
Yes. Number three is offense relating to membership of a terrorist organization. Okay, suppose in this aspect, we agree that there is a case could be made out due to his communication with the main accused.
Gosh.
Offense relating to support. Given to now, offense relating to support will again have to be connected with some event. Because I'm quite sure this terrorist organization would be having number of activities, number of illegal activities they've done, extortion maybe,
Gosh.
maybe I don't know, whatever illegal things that. So this will have to be specifically spelled out. So say membership, okay, maybe true. Conspiracy, maybe conspiracy, but with regard to what aspect? Which act? Was it grenade? A1 could have been involved in number of
Grenade plus.
legal activities. So which one? Harboring, let us see these aspects. I do not know if the way that we are thinking is correct or not, but this is one way of looking at it. Yes, so what does the charge sheet say basically? What is the offense?
I've already read, madam. Page 60.
Page 16.
You know, madam.
Page 54.
It starts from 54.
Page 54 of the earlier one. no?
Page 54, my lord, para 17.20.
Of criminal level 275.
Page 54.
And para, my lord, you could kindly note it, para 17.23 of the charge sheet.
Active supporter and activist maintaining links. Okay, this basically points to him being a member.
Flush.
It is not connected with the grenade blast. It is not connected with any specific criminal act.
Lordship, I have given bunch of papers, Lordship, which includes the statements recorded.
Okay.
I will be referring to, if your Lordship will come to page 55 of that one.
Yeah.
55. It's a statement of Putul Bush, sir. Lordship has got it.
Page 55. 55.
55.
Of,
Of
oh, okay, okay.
Oh, this one.
Page 50.
Page 55.
Yes.
I would take your lordship to specifically page 60, where it deals with the present appellant.
Yes.
Page 60, lordship has from Indra Mohan Bora.
Yes.
This is a statement of the Assistant Commissioner of Police, Chandmari. And coming to Indra Mohan Bora. I'm just reading out first. Sri Indra Mohan Bora, son of Rebakanta Bora of Puranigodam, Solsoli, PS Samuguri district, Nagaon, was arrested with the help of Nagaon police, and after thorough, this should have been interrogation. He was arrested and forwarded to the CJM Kamrup M on 18/5/19 and taken in police remand for 14 days and interrogated thoroughly. He stated that he has a Facebook account in his mobile number 700, this number, lordship, in this number, lordship, it was showing some 33 calls
33 calls.
with A1 and wrote Sadhinata in his profile, Octopus, Alpha account. Contact him in his Facebook and account and instructed him to call some new Alpha cadet. He asked some boys, but nobody was willing to join the Alpha. Octopus asked him to help Alpha cadet if required any help. Bijoy Akham contacts him over phone to pick up him from Nagaon bus stand to Uriagaon. All total 4 times he pick up Bijoy Akham. Bijoy Akham is that A1 lordship.
Acha.
From Nagaon bus stand. About 15 days back, since his Bijoy Akham called him over phone to come to Guwahati by his motorcycle, accordingly he came to Guwahati by his motorcycle and met Bijoy Akham near Ganeshguri flyover. And he came to Chandmari by his motorcycle with Bijoy Akham as per his request. He came to Chandmari via Zoo Road and dropped him near a Gulchakkar. He stated that Bijoy Akham gave him rupees 1,000.
Who stated?
This appellant,
Indra Mohan.
Indra, gave him rupees 1,000 as petrol cost for his bike. On 16/5/2019, Bijoy Akham called him over phone and informed him that police is searching for him. So he is going to Nagaon to take shelter in his house. Accordingly, Indra Mohan Bora took Bijoy Akham from ASTC bus stoppage on 16/5/19 afternoon to his house and gave shelter to him for the night in his house. Next day morning, Indra Mohan Bora dropped Bijoy Akham at Nagaon bus stand and came back to his house. Therefore, lordship, what is apparent is that he had in fact given him some kind of a shelter, lordship.
Harboring a fugitive.
Lordship. And he was called from Nagaon to Guwahati. They did a receipt in the.
But these are all statements made by the police.
Lordship, that has again to be proved, lordship.
But how can it be proved, my lord, when the accused has made a statement in the presence of the police, my lord? It's clearly non-admissible under section 25. I'm surprised, my lord, my learned friend is reading what police took it out from interrogation, my lord. There is a clear bar under 25, my lord.
Let us see the other statements, lordship. I just take out, lordship.
Let us see some independent witnesses or something. Or maybe any 161 or some 164 or something like that. No 160.
There's a statement of lordship, the SP, Nongam.
Okay, we're taking about 2 points.
Too much.
Manipur method.
Okay. Okay, we'll adjourn the matter then, your matter. Will be approved for that.
Your lordship, let that it be a fixed on 22nd Jan. Sorry.
No, no, no. Oh, yeah.
I think, week case lordship is without lordship. Matter is very volume in the lordship. Saturday, Sunday, 2 days is required to go through all the documents.
So we list it where?
Any Monday lordship, any Monday,
Monday?
Monday,
Monday, okay.
Monday or Tuesday lordship.
6th February. List on the prayer for adjournment made on behalf of
Yes, Borgohai.
S. Borgohain, counsel for the appellant. Who is on legs, no, who is having hearing
Yes, your lordship.
by virtual mode
Yes, your lordship.
in a matter relating to the Manipur High Court. List the matter on 6th February.
6th February.
That's item number 7 to 10.
Thank you. Obliged, your lordship.
Yes,
My lord, in this item, item number 9, appearing for this item number 9. 7 to 10. I'm appearing for item number 9.
so you want your name to be reflected?
My name to be reflected.
Okay. Mr.
D. Nandi.
D.
Nandi.
Nandi appears for,
Rudhan Chakma.
no, appears for the appellant
Appeal,
in criminal appeal number.
Criminal appeal.
Item 9. Criminal appeal number 50/2017.
50 sir.
While Mr. Huh?
Item number 7.
While Mr. P. Datta appears for the appellant in criminal appeal 266/2016. Huh?
Yes, sir.
What to do? We can't dispose of. Though we have heard it.
Almost 17 years.
Huh?
It's almost 17 years.
No, we are ready. The problem is their batch of petition. And if one of your friend, I think he's the only one who has not finished his argument. Otherwise, everyone else has finished. I mean, there's nothing to argue about. If the facts are clear, I mean, kidnap, ransom not paid, death. That's all.
Confessional statement.
Confessional statement.
27 evidence leading to discovery of the water limit.
But what to do? He's on his legs in, I mean, he's having another hearing. What to do?
4 5 days. Sir. Last 4 5 days we have been appearing my lord. Consecutive. It's very voluminous to bring all the records together.
Correct. No, we understand fully. That's why we are prepared to do our part of the job. Unfortunately, when one of you all decide not to do it, then it becomes a problem. Day before yesterday, we were hearing a matter. 11 appeals, I think, are there, Mr. Chaudhary. And we were ready to dispose of, but then there are times they were adjourned it on one some ground. What to do? Yes.
Lordship, I would like to take your lordship to the bunch of papers, lordship.
Yes.
Papers,
61.
page 76.
76.
This is a statement of a neighbor. That is Rafiur Rahman.
Now again, where is your counsel? This is not done, huh? No, no, no. The applicant's counsel, appellant's counsel.
Why Harry Potter?
My lord, he is on way.
Huh?
My lord, he is on way.
He's on the way.
He already came, sir.
Huh?
He already came, sir.
Really?
Yeah.
So where is he?
He is coming, sir. 2 minutes. You can proceed.
Lordship, page 76.
Yes.
Refuse.
Yes.
He is a neighbor of the accused, Lordship. My name and address cited above is correct. I read up to HS second year. I've been working as a teacher in so and so since last 1 year. On 17/5/19 in the evening hours, while I was at my house, police called me and asked me to come to the house of the accused Indra Mohan Bora. I am neighbor of Indra Mohan Bora. Accordingly, I and one Muhammad Abidur Rahman of Solsoli Muslim Gaon went to their house. Police asked some questions to him in presence of us. Indra Mohan Bora admitted that he was directly involved in the grenade blast case in Guwahati on 15/5. He knew about Papu Coats, alias Vijay Assam, whom he helped after the incident occurred. Further, he stated that he was going to show some articles, his mobile phones, pen drives, which were used by him and kept hiding by digging in the backside of his house. Accordingly, Indra Mohan Bora led us and police team. He made a hole and took out a polythene bag and showed 2 numbers of mobile phones, SIM cards, memory cards, 4 numbers of pen drives and the knife, etc. And police seized those items in presence of me. I, along with Abidur Rahman, signed on the seizure list prepared by the police. It is mentioned here, the police interrogated Indra Mohan Bora and Abidur Rahman and me for 2 times before and after seizure. The article showed by Indra Mohan Bora. Singular statement is given by Abidur Rahman at page 77. I'm reading from the 4th line. I'm neighbor of Indra Mohan Bora. Accordingly, I and one Muhammad Rafiur Rahman of Solsoli Muslim Gaon went to their house. Police asked some questions to him in presence of us. Indra Mohan Bora admitted that he was directly involved in the grenade blast in Guwahati on. He knew about Vijay Assam, whom he helped after the incident. Further, he stated that he was going to Lordship is on the similar lines, Lordship. Now, after seizure of those phones, the photographs and all those were retrieved. And if I may take your Lordship to page 38 of that same.
Acha, first of all, this Rafiur Rahman, his PW number?
111, 110, sir.
And Abidur Rahman?
111. As per 161, CSW 110 and 111.
That's for the charge sheet.
Yes.
So long way to go before he is 11.
In the photographs materials retrieved from the mobile phone Lordship. Those contain the photographs of the accused number 1 as well as the present appellant Lordship. And it transpires Lordship that they were in touch because if I may take your
No, we agree, okay, they were in touch, supposedly. But how do we know that they were involved in this grenade blast?
Lordship, he was not directly involved. Lordship. Present appellate, it was not him that who has lobbed the grenade. Grenade was lobbed by accused one.
No, no, maybe, but how do we know that he was in the know? Or he was in the knowledge that this grenade was going to be blasted,
Lordship,
except for this statement of this witnesses.
these two witnesses, and Lordship, if we go through the analysis of the telephones, which your Lordship will find at page from page 14, Lordship. Of that,
Page 14.
page 14, Lordship. Here, Lordship. During the analysis of CDR of mobile numbers, this one, last number 731 and 719, these are the phones which belong to the appellant. It is revealed that the accused Indra Mohan Bora was connected with his mobile number 731 from Papu Coach Bogolia, that is the accused one.
Where are you reading?
At page 14, if you
Page 14, which part?
just above the
Okay, okay.
based on the available CDR, so and so, the following table and chart is prepared. It contains the connected accused and suspected person's name and mobile numbers. Now, 244 mobile number
Yes.
is of the accused number one. He is the prime suspect, Lordship, who has
Yes.
lobbed the grenade. Now, if I may take your Lordship, and Lordship will find the connectivity chart, there has been 33 calls in between them. Now, if your Lordship will come to the next page.
Yes.
Lordship will see at serial number 1, 26 April 19, there are two calls from the accused number 1 to the appellant. And if I take your Lordship to page 18, now Lordship will see the accused number 1 has contacted him immediately after this incident. I'm just reading out location-based analysis of mobile phone numbers of accused Papu Coach Bokolial, so and so. Last number is 244. Established the fact that on 16/5/19 between the period so and so, location of Papu Coach Bokolial was found in Nagaon, which mentioned in table 9. Location analysis, based analysis of mobile phone number, so it's mobile phone number of accused Indra Mohan Bora that established that the fact that on 16/5/19 between the period so and so, his location of accused was found in Nagaon. The CDR analysis of both the mobile phones established that they were in touch with each other through their above mentioned mobile phones. The above mentioned analysis corroborated the statement of Papu Coach Bokolial that after grenade blast, he had taken shelter at the house of Indra Mohan Bora on 16/5. Now 16/5, Lordship will see the second one in the table. 16/5, 15/5 was the incident. 16/5, he calls up one.
Okay, so what does this prove? That he called up, so bomb blast occurred on 16/5/19,
On
correct?
15,
15/5.
15.
Now, so he called up, so what does it prove? What does it
Yeah.
imply? It implies that they spoke to each other, but what did they speak about?
That is there. That of course is not there. And
Can we, suspicion, however strong it may be,
blush.
can we say that though it is plausible that they spoke about the grenade blast and whatever, can we say that it is that was the topic that they spoke about? Can we prove anything by the making a phone call to each other without knowing the contents of the speech? Though it can be said this,
Yes.
then it is proof enough that he was part of the organization. But can we say that it implies that they were talking about the bomb blast? Or that they were involved in the bomb blast? Can we say that?
Lordship, as a matter of fact, the retrieval from the mobile phones would indicate that he was involved with the farm.
That is all right. That is all right. That part is all right.
Now, why would the accused number one of all people only speak to the appellant Lordship?
How do you know he doesn't speak to others?
Lordship, no, there are a few Lordship, and if your Lordship will see the chart at 9, this table 9.
Chart at?
Table 9, Lordship, at page
Table 9,
18.
yes, yes.
Lordship will see there are 6 phone calls within a short time between them, Lordship.
If you look at the timing, 14:06, 14:25, 14:25 again, 14:27. These are all 2 o'clock, 2 o'clock, 2 o'clock, both of them.
Yes, Lordship.
Could it be due to bad connectivity that they're calling each other again and again? Today, while sitting in my office, here, my chamber, I can show you my phone also. One person called me 3-4 times because we were always getting cut in the middle of our conversation. Or was it yesterday evening? I'm not sure. One of them. This morning or yesterday evening. We're getting cut all the time. I know location of my chamber is something wrong. I think. So does it? Anyway, I'm just saying.
No,
But
Lordship,
what I'm saying is this number of calls, say 6
Yes.
calls, whatever. Does it prove anything with
Lordship, calls coupled
that
with
they know each other?
that is another
As
aspect,
a-
knowing
as
someone.
As a lawyer, as a lawyer also, we know a lot of people who we defend
Lordship.
and not defend also. And then sometimes we talk to them beyond office hours also. You know, so I mean, unless there is that speaking to them over the phone without knowing the contents of what is being spoken, can we imply that they must have been talking about this aspect? And
Yes.
I'm just
Yes, yes, I do get your
Suspicion.
Lordship. I do get your Lordship, but coupled with the fact, Lordship, that whatever retrieval has been made from his phone, that shows the accused number one.
they knew each other.
They knew each other, they were in touch with each other, and apart from that, there are some materials with regard to the band organization itself. So that gives an indication, Lordship, that though they were knowing each other, why would anyone, it's me, I have done so many cases, why would I keep something from the alpha, Lordship? Of the alpha?
Ah.
I would not give anything, Lordship.
No,
Personally,
no, I'm not on that. The issue is this.
Lordship.
According to us, there are two things. One is that he is a part of Alpha. That is one aspect.
Lordship.
The second aspect is being a part of Alpha. Is he involved in each and every act of Alpha?
He-
That is now that is where the because punishment for being Alpha, okay, that can be taken care of. That is okay.
That is okay, Lordship.
But being a part of a particular terrorist act while being in Alpha is different. Because say there are 100 persons or 1,000 Alpha persons, and there is a bomb blast in some part of the state. Can we say that all 1,000 of them were involved in that one bomb blast? So that's what I'm saying. Can we say that this particular applicant can be said to be involved in that grenade blast out of maybe 1,000 Alpha persons? Or can we paint everyone with the same brush?
Lordship,
Because that being an Alpha, that will be a different punishment. Doing a terrorist act and being a terrorist act, that will be, I think, a separate act also.
yes, Lordship.
Or maybe he can be doing both also,
Lordship.
or he can be doing one only. He'll be a part member, but not doing the act, or being a member plus doing the act. So he can be charged under two sections. Now, in this case, okay, he's a member of Alpha, assuming.
Lordship.
Was he involved in the act? That part. How can we say that yes, he was involved in the act? Just because he knew A1?
Lordship.
What I would say, all, no, but all may not be involved in the main act. That is all. There are some, because it all organization. So some may shelter. In my case, he brought or he supported one A1, that is with the home culture. So these are the small acts which they perform in pursuing the whole, the bigger goal. So each of them had a role to play. It is not that each of them will go at for the goal.
But just supposing, A1 is supposed to have thrown the bomb, the grenade. Now, supposing this present applicant had harbored him, given him shelter, without knowing, I'm assuming, without knowing that a grenade was to be planted or thrown. Can you say that this applicant
But that
was involved in the throwing of the grenade?
that knowledge, his knowledge has to be gathered from his activity, what he has done. Why was the call?
But
Within
where is the shelter being taken? Where is the harboring? How do you prove that? How do you prove that the applicant harbored A1, accused number 1? How do you prove? Where is your evidence?
Immediately after the blast, this A1 has to clear. Has to clear. That has to.
Has the free, has the free.
So what he has done, he did not call anybody because he knew A5. So he rang up A5, he went to Nagaon, and from there he tracked.
How do you know that? Who said that?
That is only from the phone call. That is call letter record.
Call data record does not say that the one that A5 took him away. He just called. The call record only shows who called whom. The contents of what they said,
That is
not
the-
known.
But yeah, prima facie, but that is his connection. Why would he call A5?
Oh, happy
Why not?
birthday, happy birthday. Happy anniversary, baby. Happy.
Too long a story, Manoj. Happy birthday to a person, Manoj. Because they are very busy with their goal. So I would say, Manoj, these are the sort connection, keep beats, Manoj, that has to be pieced together. And that has to be understood. And their mental condition. The only thing is that mental condition. Is it that it's all innocuous, that there was nothing made, or was there something? If you're also find yes, seven Brahmas is something. Yes, as the prosecutor said that he supported or he helped, then definitely there is a permanent ground, permanent education school. I think what's it-
No, you see, prima facie, it appears to show that he has a connection with the organization, no doubt. But how do you, where is the evidence suggesting that he was in the knowledge that the grenade was going to be thrown and that he was a part of that conspiracy? How do you prove that?
Manoj,
Can you go just because he knows they know each other? Can that be a ground?
that
Or they called each other without knowing the contents of what they spoke? Can that be a ground?
that has to be added 1+1, Manoj. This man, Vijay, he had to flee after the incident. They knew that there was a full plan because immediately after Gopal, there was telecast etc. and all everything. There was a big uproar. 12 persons got injured and 2 were very serious, one of them is permanently injured. So, but when it was reported in the TV and some media, so this person has come to reported that yes, this man has.
How long do you think the trial will take place?
For the trial, Mother.
How long will it take to end? Yeah. Huh? No, once it starts, so that's a different issue. Maybe the, and how many witnesses have been examined? 20 examined or 17? 20 examined. And altogether 177 witnesses.
We are not going to be all.
What has happened, Manoj? For one incident, one piece of evidence, Manoj, there are 3 to 4 or 5, 6 witnesses are there. So, we do not know that whether all this will be found at the time of examination of the witness, Manoj. Because somebody may leave the place, etc. So, if that 1 or 2 is examined, Manoj, that means the rest of the witnesses. So, in that way, Manoj, although there is a additional 100 so Manoj, it may come down to short. That is what we have seen it, Manoj. Because later on adding somebody, then again comes secretary, because you have to prepare the 161, etc. You also know. But it is better to add it here and then to delete it. We may not want that. It's a discussion of the prosecution. Manoj. So in my case, Manoj, I do not know. He has a good person, Manoj, accused number 7. He was found with fatigue, with Manoj,
Army fatigue. Camouflage.
yeah, no, Manoj, he was very
So he is wearing camouflage. So what? Even I have got camouflage jacket.
Manoj.
My friend, a friend of mine bought it from America. They're selling it out there. So, camouflage jacket. Here also they sell it in so many shops. T-shirts. You go to Decathlon, you'll find all the camouflage T-shirts out there.
Manoj, no.
Camouflage jackets will be of no use unless you have got some toy pistol or something with you.
Not
Water pistol or
Not
something.
only come from Manoj. he was in the jungle, in Myanmar, Malo. He accompanied A1 and then he snapped a photo with,
No. You see, that aspect of he being alpha, it appears to be, it appears that, yes, he's an alpha member. But whether he's involved in the incident, that has
He's
to be
mixing
proved.
up the other case. Indra Mohan has got nothing to do. That's the other case he is making submission.
other case, but I think that's
Other than next week.
So your lordship will not get nothing. So for this case, no come up with nothing.
So in any case, Maharaj, the only thing is that Maharaj, that generally they are very selective, Maharaj. They won't trust any other person unless they know and they have confidence of anybody. Because that may affect that is loss of life, etc. So they will contact only those persons who have.
No, they're supposed to do that. They're supposed to be very confidential, very secretive, naturally.
Very secretive. Maharaj.
Naturally, they cannot advertise in the newspaper, hey, we are going to come there. They have to be very, showcase.
Not talk to me because if they will talk to only to the trusted person.
No, but how do we connect that blast with him? That's what I'm saying. Just because he knows the A1. That might be difficult.
When a particular act has to be performed, you need.
Only thing is that evidence of those two persons, there are those two witnesses. Page
Yes, lordship.
page 76,
76 and 77.
76 and 76. Huh? 161 statement. Yes. So those, unless those persons' evidence are adduced, we do not know their involvement.
Apart from that, lordship, if I may take the lordship to the memo of appeal, page 41,
41.
page 41.
Yes.
More precisely, page 42 below.
Yes.
Charge sheet. Below, the charge sheet is a portion of the charge sheet. The accused number one and the appellant hearing, they were at the same place as lordship, this tower location was found. They were in the same place, lordship. 116.5. So basically, lordship, these are lordship, the statements, if independent statement, lordship, page 76 and 77, lordship. Otherwise, there is another statement of police, 161, of course. I would not read, but all right, lordship, page 79.
Yes.
Page के बाद
No,
PW number.
Anil Das.
The SI,
Yes, lordship.
the police.
Yes,
How
lordship.
is this help?
No, lordship, he was there during the season, lordship. I, along with so and so, had went to search and raid the houses and premises of Sanatan Bora, the father-in-law of accused Indra Mohan Bora, and apprehended Indra Mohan Bora. And as shown by his father-in-law, we seized his motorcycle, so and so. During search, we found and caught one wanted criminal in the so and so. He was at the house. During interrogation, he admitted his guilty of involved in the incident that happened in front of Central Mall, RG Barua Road. We took Indra Mohan Bora to his house located at Solsali Gaon on the Samoguri PS. We interrogated him in front of two independent witnesses where he revealed that he had hid some materials containing mobile phones, memory cards, so and so, in the backside of his house on the earth. We can find those out in front of us. Statement was recorded in this regard of the accused as well as the witnesses has led has has led us by the accused Indra Mohan Vora. We went to his house via his courtyard to his students, and they have seized those articles. No, Lordship. That he was exactly particularly involved in that bomb blast, Lordship, I cannot say that. That is definitely very clear from whatever is there on the record. But so far as his proximity with the accused number one is concerned, that is Lordship beyond any doubt, Lordship. Two witnesses have come forward and said that yes, he has admitted that he was involved in that blast. The telephone tower's location indicate that on the next day, on 16th, A1 was with A5, that is within the tower range, I would say. I would not say that they were in the same house, but the tower location of both the persons were the same. And this cannot be a Lordship, as it has come from my friend, Mayor Cornelius. I'm so grateful. So, Lordship, prima facie, Lordship, he is in some way involved in that incident, that cannot be brushed out. Lordship. That cannot be brushed out. Now,
Yes.
only thing that your Lordship has to consider. This would be from the records of the report submitted under 170. I would submit that Lordship will, at this moment, may not go into the evidence before the trial court, because that is for the trial court to decide. Now, what was before the trial court in the police report, that your Lordship will see. And on top of that, if we go by the judgment rendered by the Honorable Rajiv case, whether there is any violation of the facts. Apart from, if my friend relies upon, that is the judgment as on date. Najib.
He's going to say the same. Just the delay in disposal of the case.
In line of
Sorry,
Supreme Court.
Lordship, that court machinery or administrative machinery, Lordship, we do not have any control. It has to.
That is going to be his.
No, that is the
that-
precise submission.
Yeah.
That is the precise submission that is going to come. But at the same time, the court cannot be oblivious of the fact that there is only one court. There is only one court, special court out here. And how much can a court work? Yes, it is true that maybe if I have to accept his submission, some fundamental right is being violated. But once a person is released, court will also have to see what will be the effect on the society, Lordship. In any case, a court grants an interim order. In another case, my friend is there, some other case, where an interim order has been passed that a person is involved in money laundering, he is right now in Dubai, and the court has passed an interim order, no coercive action. Where the Supreme Court says, when passing an interim order, the court has to be conscious of the fact that yes, his rights are there, but what about the rights of the society? Once you release him, what is the message that we are sending? That is my. Yeah. This is Lordship is very aware that my friend is very.
Yeah.
He's into Lordship knows. So far as Lordship, 161 statements, and Lordship, that's the second page. It starts with the paragraph, the High Court.
Yeah.
So I need not reiterate Lordship, but for the consideration of bail, 161 statements are material. It may not be material in evidence, Lordship. I conclude, Lordship, because Lordship will just bear in mind, Lordship, it's not a simple case of someone stabbing someone or killing someone, Lordship. This is something which has been done to disrupt the society as such. So perhaps Lordship will keep in mind the consequences that the impact that that will be seen in the society. If it is not.
Well, I'll just take a few moments, my lord. Just to first, I would like to reply to his certain queries, my lord, certain submissions, and then I'll sum up my argument by way of bullet points, my lord. So, my lord, what I submit, my lord, in this case, the 8 accused persons are facing trial. 2 have been granted bail by our Honorable High Court. One is Amrit Vallabh Goswami. He is at search sheet page 58.
Page 58.
Yes, my lord. And if we take his submission, my lord.
Page 58.
Yes, sir. Page 56, it starts.
Which item?
Yes, ma'am. Yeah, it's, yeah.
275.
Yes, 275, madam. Right, ma'am.
Page 58.
No, page 58 is the relevant. It starts earlier, madam. 56, it starts. That is Amrit Vallabh Goswami, madam, para 17.24. Your lordship, at page 56, on the top, your lordship will see that Indramohan Bora and Papu Coach A1, who is the master blaster, his call details.
No, I don't have page 58 is something else.
Page 56, madam. Chart sheet, madam. Inner page 30.
Page 56 is this. I've got. What is this?
Yes, that is it.
Huh?
Yes, madam.
That's the chart sheet. Yes. Okay. 7 to yes.
My lord, first line I'm reading, my lord, connectivity chart of accused Indramohan Bora with accused Papu Coach
Yes.
is this, that I and he was having 33 calls. And from the same phone, there were numerous calls. Nothing was analyzed except my calls were analyzed. So that is one submission, my lord. So this man with 33 calls is behind the bars for this. Now let us come to A6, who has been granted bail. That is, his name is Amrit Vallabh Goswami. And he was having a chain of calls. If your lordship will now turn to page 58.
Yes.
The chart shows, my lord, that he is having phone with Prakash Rajkumar. He is having phone with Jahanavi Soikia, who is the main brain behind. And all these calls were made by him, and the total comes to around 101 calls in between all the main accused.
Where is Papu Conch? Is not here.
He is not here, my lord. But other conspirator, Jahanavi Soikia, who managed all the logistic support by providing the.
She's A what? She's
See,
accused number?
she is A2.
A2.
A2, my lord.
And who is A3?
A3. The Pranay Rajguru, my lord. Pardon?
Ah.
Then your lordship. will
And
see
who is
the chart.
A4? Who is A4?
Chinmoy Dotto 1, my lord.
He's not here. He's
Law
not-
court. Chinmoy Law court, my lord. Then A5 is this, our
Ah. How many accused are there?
8 and 2 absconding, I believe.
Three absconding. That is Forest Borua. They are all brought in, right? No, Forest Borua is Orun Dahotia. How? See, you will be in trouble. I think, my lord, now coming to the fact, my lord, that this, they were having, who were granted bail, they were having 101 calls. And the other accused person who has also been granted bail is one Prakash Rajkot. That your lordship will see the
Prakash Raj Kaur, what
Yes.
is his A? Accused number?
8.
He's here in this chart also, page
Yes,
60.
Page 59.
Prakash Raj Kaur, there, why is it two Prakash Raj Kaurs in page 58?
My lord, from him, all the.
No, why are there two names? Two Prakash Raj Kaurs there.
No, one is Papu Coach, one is Pronomoy Rajguru. Acha, here, yes, your lord. I was also a bit
Page
confused.
58.
Yes, correct.
Why is it two?
One is Pronoy Rajguru, my lord.
No, that's all right. What about the top?
Then come Prakash Rajkumar.
Then on the right again,
Yes,
Prakash
yes,
Raj Kaur.
35 and 13.
There are two numbers, lordship.
Oh, there are two numbers, that's why.
That's why, yes.
So who has been granted bail?
This, my lord, A6, Amrit Vallabh Goswami, and A8, Prakash
Kaur.
Rajkumar. Yes.
Where is their bail orders?
My lord, Prakash Raj, bail order is of Amrit Vallabh, is 2021. I have given your lordship. 2021 to GLT 751. I have made a comparative chart also. How his case and my case are similar. Well, just citation, I'll give your lordship right now. 2021 to GLT 751.
2021 to GLT
751.
751.
And the Prakash Raj Guru case is in the other case, my lord, where Sanjeev's bail was rejected and his bail was granted, which I have shown your lordship. In BA 340. Page 112. On, the order to High Court order.
Sanjeev Talukdar.
Yes,
This-
my lord.
this is
113 is the.
This is different.
That's
You said that Amrit
Vallabh Borua.
Amrit
Amrit Vallabh Goswami.
Goswami, he's this 2021 to GLT, this is
Yes.
pertaining to?
Absolutely. Amrit Vallabh Goswami. He is A6, my lord.
Then what about Prakash Raj Kaur?
Prakash Rajkumar was also granted bail, and his bail order, I have annexed it in Criminal Appeal 340 at page 112. That is not probably reported by in GL.
340.
Yes.
The page?
Page 112, page 1.
No, this is Sanjeev Talukdar.
Yes, my next page, your lordship will. 113, that's right.
Okay.
There were two accused before the lordship, dealt with the same matter by a
It
common.
pertains to the same grenade blast or what?
Yes, same, yeah, right. Yes.
So this 2021 to GLT 751, this is also with regard to the grenade blast.
Same, my lord, same, my lord. A6 and A8 were granted bail, my lord.
Okay, now let us see this 2021 to GLT. Have you got,
No, my lord. I think we have.
what is the basis for granting bail there?
My lord, there's the length of detention
Length of detention and
Yes. and the direct incriminating material regarding the throwing of which your lordship is putting it was not before the court. No evidence to show that they were directly. engaged with them.
2021 to GLT 751. Is it a long order?
Not that long, my lord.
Not that long means how many pages?
5 pages or 6 pages.
2021 to GLT 751. And what about this this Prakash Raj Pawar's
That is already there, my lord, at page 130.
No, no, both. No, Sanjeev Chaturvedi. And the next. Amrit is a different. What are the basis for giving bail out here?
My lord, if your lordship will just kindly see, I have given a chart, my lord, on what basis the bills were granted, and page 11, my lord, my type one.
Huh?
My type version.
GLT is not working. Page 11.
Yes, my lord.
Huh? Yes, what
Yeah,
about it?
I'm just giving my lord, just one moment. এখন তো my lord, I'm just pointing it out, my lord. I have with me. It was it. It is 1, 2, 3, 4, 4 page, my lord. No, chapter 9,
Yeah, in this, is it here?
Yes, my lord. Earlier it was given. Yes. If your lordship will now see, my lord.
Fourth page.
Yes, comparison chart has been prepared wherein the Amrit Vallabh Goswami's role and my role has been compared, my lord, vis-a-vis the judgment, my lord. Page 11 of my type. I have given today list of dates and everything. my lord.
This one?
Yes, my lord. Page 11, if your lord,
This page 11.
no, my lord. Regarding Sanjeev Talukdar's actually I have put it, sorry. No, that is with Sanjeev Talukdar I have compared it. With him, I have not compared it. Sorry, madam. The other case I have compared. I'm so sorry. So, my lord, I was just pointing it out, my lord, regarding the phone calls, my lord. I'm coming, my lord. It's kindly bear with me. My lord, regarding the phone calls, my lord, so far A8 is concerned, my lord, he was having some 101 calls, my lord. So they were also, in spite of that, they were also granted bail, my lord. And lastly, if your lordship will see, my learned friend has pointed it out at page 40.
Let us see the GLT.
For the time being, your lordship, I have one. In the other case was judgment like Diaz and case.
No, no, the judgment is here, but then where?
No, we have money. But in the other case, actually, that's why there is a bit of mix up. But I'm giving my 4 pages. Most probably in the other case, it is all there. No, second case too. আমার record করা হয়। Fine. Because once we argue it.
Amrit Vallabh. Okay, dear. Yes. Nothing much.
Okay, finally, just one more line from the charge sheet, your lordship will see at page 42, which my learned friend has pointed out. In the charge sheet, what is mentioned, my lord? At page 42, my lord, I'll just read the last paragraph.
Page 42 of your petition.
Yes, my petition, my lord. Present petitioner, relating to A1, the narration starts for 5 pages, my lord. It starts from page 38, evidence against Pappu Coach Boklia versus Bijoy Ahom, Anvi, Rajini. All this starts from 38, 39, 40, 41, 42, it ends probably. Yes, 42, it ends. And in that end para, I have been connected with this accused person while dealing with the case of Pappu Coach by writing 3-line para. Tower location of accused Pappu Coach, alias Bijoy Ahom, page 42, my.
Yes.
It starts from page 38.
Yes, yes.
When the,
Yes.
yes. Roman 7, my lord. Tower location of accused Pappu Coach, alias Vijay Ahom Anvi, on 26/4/2019 and 16/5/2019 was in Nagaon, where the house of Indra Mohan Bora is located, which indicates that he was with Indra Mohan Bora on 16/5/2019. It is a mere fantasy, my lord. Just because the tower location of his showed that he was in Nagaon, and I being a resident of Nagaon town, but staying in Samuguri, nearby place near Nagaon, my lord. So by writing that just because the tower location of his and mine shows the same place, my lord, for that I am supposed to be an accusing. That is while narrating the incident of Pappu Coach. They have come up with these 3 lines. Rest are all with the other co-accused, nothing to do with me, my lord. While dealing with the case of Pappu Coach, the CBI has just mentioned at para 7, 3 lines. That my tower location is Nagaon will be shown because I stay in Nagaon, I do business, but I stay at Samuguri, a place nearby in the Nagaon district. That is at while dealing with it now. Now, my lord, just to sum up, my lord, this is what transpires from the documents, my lord. Now, while summing up, my lord, I have also narrated my points, my lord, at page 6 of my written write-up, my lord.
Yes.
My lord, page 6, your lordship, all points argued before the court for your lordship. So first thing, he is aged about 20 years and is only the male member who can look after because they are aged parents, and he has got a seriously able brother and the daughter is 3 years old. That is one consideration. And the other is that I am behind the bars, that needs correction, my lord, is 4 years, 7 months, 22 days as on today, my lord. Your lordship has already taken note, but it was earlier argued than taken. So the present accused does not have any criminal antecedent. It is first time that he has been allegedly implicated in a case, my lord. That from the seized mobile of the accused appellant, nothing incriminating was found, and by the near no photo or any inculpatory material was also found to incriminate the accused appellant with the commission of the alleged offence that took place on 15/5/2019, and also to connect the accused appellant allegedly to have linked with the alpha. That there is not an iota of evidence on matters to even remotely suggest or connect the accused appellant with the alleged occurrence, that he has provided logistic support to the cadres of Alpha, by providing transportation to Alpha cadre, and has actively participated in the reconciliation of the target with the Alpha cadre. Moreover, there is no material to show that he is also actively associated with the conspiracy to commit terrorist acts in pursuance with the goal of the Alpha. So, my lord, I have given all my bullets points, my lord.
When was he arrested?
On 2 days thereafter, my lord, 18, my lord. 18/5/2019, I was arrested. FIR and occurrence is on 15/5. On page 27, your lordship will find it, my lord.
That means 4 days later arrested.
Yes, my lord, 4 days. So, my lord,
That's all.
my lord, that's all, my lord, your lordship, I have already put it. Only those correction may kindly be made because this was prepared some months ago, my lord, while arguing it before another time. So this needs, my lord, that I was behind the bus since 167 days, round about more than 4.5 years, my lord. And at page 12, if your lordship will kindly note down, my lord, out of the 170, 15 till date, only 20 witnesses have been examined. Earlier it was 16 witnesses and 237. So I have incorporated the points, my lord, on the basis of which I am seeking bail on merit also. Apart from the Honorable Supreme Court judgment, my lord, saying that length of detention is also one of the factors in so many cases it has been said. And two accused person has already been released on bail and they are still facing the trial.
Same case.
Same case, my lord. And their role was much higher than me. My only role is that I harbor, that is the allegation of course, that they will prove it during the trial. And I was only having link and phone call with one person, that is Papu Coach.
Does it say Harvard?
No, not at all. Harvard, you have to give the shelter, give it time. Harvard, your lordship will not find the definition directly under the unlawful activities act, but under the prevention, sorry, penal provision, my lord, it is harboring is mentioned, my lord. Whoever knowingly is the word, my lord, so far I remember.
He has provided logistic support.
Yes, nothing has come out, my lord. Not a whisper as to what is that logistic support. $200
Okay, anything else?
much. One. One, two, 212.
Heard Mr. Z Kamal, learned senior counsel, assisted by Mr. Dean, learned counsel for the appellant. And this is item number
Item 16, I guess.
16. Also heard Mr. R. K. D. Chaudhary, learned deputy SGI, appearing for the respondent. This appeal has been filed against the impugned order dated 8/6/2023, passed by the Special Judge NI, Assam, Guwahati, in Miss bracket NIA, that was case number 23/2023. Rejecting the bail application submitted by the appellant. Yes, Padri. Is this the case where you were asked to come after 4 years?
No,
that's
Sanjeev's
the-
case, other one, not.
The facts of the case is that the is that due to a grenade blast that occurred on 15/5/2019. Allegedly by the accused number one, that is Mr. Papu Koch, CONCH. No, KONCH.
A1.
Huh?
A1, my.
That's what A1. Papu Koch, PAPPU Koch. An FIR dated 16/5/2019 was filed and, which resulted in the registration of Geeta Nagar PS case number 210/2019 under sections 325/326/327/121 IPC. Read with sections 3/5 of the Explosive Substances Act and section 10/13/16/20 of the Unlawful Activities Prevention Act, 1967. The investigation commenced and on completion of the same, charge sheet was submitted on,
Well, can I just put in my note? Actually, Gitanagar PS was registered by a notification
Huh?
by a notification issued by the government, my lord. Then NIA stepped into the case.
okay,
That is
was issued, huh?
That was
Was registered, huh?
as Gitanagar.
Full stop. Geeta Nagar PS case, okay, under section, full stop. Thereafter, where is the government notification?
Lordship will find it at page 34 of the appeal. If I may just read it, 16.15,
34.
page 34.
Page 30 of the chart sheet.
Yes.
Last paragraph, 16.15. In view of the
First stop, thereafter. In view of the gravity of the offence, the Ministry of Home Affairs, Government of India, wide order number 11011/22/2019/NIA dated 24/06/2019 directed the National Investigation Agency (NIA) to take over the investigation. First stop. Accordingly, Geeta Nagar Police Station case number 210/2019 was re-registered as NIA case number RC-04/2019/NIA/GUW under sections 325, 326, 307 and 121 IPC. Read with sections 10, 13, 16, 18 and 20 of the UA P and sections 3 and 5 of the Explosive Substances Act 1908. What about the Sadgaon police station is different?
Same case also taken up as a number 5, will be pending of charges for
Okay, good stuff. During investigation, a subsequent police case was registered at Sadgaon Police Station case as Sadgaon Police Station case number 147/2019, which was re-registered as NIA case number RC-05/2019/NIA/Guwahati GUW under sections 121, 121 bracket A and 122 IPC, read with section 25 bracket 1 capital B of the Arms Act, section 10, 13, 18 and 20 of the Unlawful Activities Prevention Act and section 5 of the Explosive Substances Act 1908. At page 34, the last paragraph from the entire thing. Okay. So some next paragraph. After completion of the investigation, a consolidated charge sheet was submitted by the respondent against 8 accused persons. 8. Eight accused persons. First up, subsequently, a supplementary charge sheet was filed wherein 3 other persons were charge sheeted. The 3 other persons who had absconded were charge sheeted. The applicant herein is the accused number 5 in the charge sheet. Next paragraph. The learned trial court framed charges under section 18 and 18, 19, 38 and 39 of the UAP Act against the appellant, against the appellant on 3/2/2022. Next paragraph. No, first up. Thereafter, trial has started and out of the 177 prosecution witnesses, 20 prosecution witnesses have been examined by the learned trial. First up. The learned senior counsel for the appellant submits that the accused number, what is the accused number? That one,
Accused number 6 and
6 and 8, my lord.
6 and 8. The accused
Six.
number 6. Who is
Amrit.
six?
Vallabh Goswami.
Huh?
Amrit Vallabh Goswami is 6, my lord. Amrit Vallabh Goswami was granted bail, my lord,
Number 6, Amrit
on
Pallab
10/3/21.
Goswami has been granted bail on
10/3/21
10/3/21.
by this court and reported in.
Yes, where is that? You had given it to me. I have no.
Yes,
where-
yes, I have given it. The big bundle, my lord.
Huh?
The big bundle. Therefore, that's on that. Wait, তাতে আছে, 2 page, 2 page. Where you put your finger, where you put your finger.
Then it's
Just 2 repeats.
In,
Criminal.
no, on 10/3/2021. In the case of Amrit Ballabh Goswami versus NIA, reported in 2021, 2 GLT 751. Further, accused number
A8
A8,
has been granted bail. in criminal-
accused number 8, bracket A8. Prakash
Prakash
Raj
Rajpura
Kua has been granted bail by the division bench of this court by judgment dated
27/12/22
27/12/22
in criminal appeal
in case, in criminal appeal
136.
67/2020.
136 of 20.
Sorry, in 136/2021. He submits that the only reason that the appellant hearing has been made an accused in the present case is due to the fact that the tower location of the accused Papu Koch, bracket A1, on 26/4/2019 and 16/5/2019 showed that he was in Naugong, which housed the residence of, which housed the residence of the present appellant. As such, the tower location having showed that Papu Koch was in Naugong, the respondents whose case was that he must have been, Papu coach must have been with the appellant. And now full stop. As Papu coach was involved, was alleged to be the person who threw the grenade. On 15/9, 15/5/2019. Near the Central Mall at Guwahati. Yes. Comma. The appellant had provided logistic support to Papu coach, who was a member of Alpha Bracket One, which was a terrorist organization. It's I, not one.
Independent.
Okay, I. Good stuff. He submits that the recovery of mobile phones from the appellant, which showed that the appellant had communicated 33 times with Papu Conch through his mobile, was the reason that the respondents had come to a decision that had come to an erroneous decision that the appellant was also involved in the grenade blast that occurred in Central Mall. Next panel. The learned senior counsel submits that as only 20 out of the 177 prosecution witnesses have been examined, despite the appellant being in judicial custody for more than 4 years and 7 months.
21 days.
The appellant should be released on bail. In terms of the judgment of the Supreme Court in the case of Union of India versus K.A. Najib, reported in
2021, 3 SCC 713.
2021, 3 SEC
713.
7-1. As his rights under Article 21 of the Constitution is being violated. That's all? Yep.
And-
Next, sir.
And one line I forgot to say, my lord, in this case, my lord, so for these accusations, no terrorist activities case has, charge has been framed. Like, possessing of illegal arms, like possessing of any.
That will mention.
That's, I am submitting.
Right. Mr. R.K.D. Chaudhary, the Deputy SGI for the respondents, comma, on the other hand, submits that the statement made by statement made by
It's 76 and 77.
Acha, what about Putul Baishya?
Lordship, I'm relying on that.
Submit that the statement made by Shri Putul Baishya, APS, Assistant Commissioner of Police, Chanmari, recorded under section 161 CRPC, is to the effect that the appellant had stated during interrogation that who is this Bijoy Assam? That
He's
Huh?
alive.
submitted that, had submitted that. What is that? That Fukan, not in the coach. What is his name? Huh? Papu Coach. Papu Coach had contacted him over phone to pick him up from Nogong bus stand. And that the appellant had picked up Papu Coach. Further, the appellant had given shelter to Papu Coach in his house on the night of 16/5/2019. And dropped him off in the Naugong bus stand the next day. He further submits that as per the statement given by PW 110 and 111 under section 161 CRPC, the appellant had admitted to them that he was directly involved in the grenade blast case that occurred in Guwahati. The grenade blast, the grenade blast that occurred in Guwahati on 15/5/2019. And that he knew Papu Conch, alias Bijoy Assam, whom he helped after the incident occurred. Next paragraph. The learned Deputy SGI also submits that in view of the discovery statement made by the appellant, two mobile phones, SIM cards, memory cards, and 4 pen drives, knife, etc. were recovered from a hole made in the earth from the back of the appellant's house. As the CDR of the mobile of the appellant showed that he had been in constant touch with Papu Conch, the appellant having been a part of the terrorist act involving the grenade blast. The prayer for bail should be rejected as the same would not be in the interest of the society at large. Anything else? We have heard the learned causes for the parties. Section 43 D bracket 5 of the UAP Act 1967 provides that no person accused of an offence punishable under chapter 4 and 6 of the UAP Act should be released on bail unless the public prosecutor has been given an opportunity of being heard. Full stop. It further provides that such an accused person shall not be released on bail on a perusal of the case diary or the report or the charge sheet. If the court is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Person. Any problem? No, no. In the present case, comma, charge has been framed on 3/2/2022. And as such, it is clear that a prima facie case has been found by the learned trial court to be made out against the appellant. Full stop. However, this does not preclude this court from considering whether the accusation against the accused person is prima facie true. Keeping, no, be that as it may, comma, the Honorable Supreme Court in the case of, where is that case again gone? Najib. No, K. Najib Supra has held that the presence of statutory restrictions like section 43 D, capital D, bracket 5 of the UAP Act does not oust the ability of the constitutional courts to grant bail on grounds of violation of part 3 of the Constitution. Full stop. As such, comma, we are of the view that no, as now, full stop. Where is that Najib case? It is somewhere here.
It is there.
Yes.
Yes, yes. It has further held that both the restrictions under the statute as well as the powers exercisable under the constitutional jurisdiction can be well harmonized. It's in para 17, huh? Pusta. It has, however, provided that the rigors of the statutory provisions would have to give way, would give way, would be less rigorous, let's say, would be less rigorous, where there is no likelihood of the trial being completed within a reasonable time, and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Gustav, such an approach would be a safeguard against the sole condition for denial of bail, which could result in the breach of the constitutional right of an accused person if only section 43 D bracket 5 of the UAP Act was to be the sole benchmark for deciding a bail application. Full stop. In the present case, next para, in the present case, comma, the questions to be decided by the learned trial court relates to section 18, 19, 38, and 39 of the UAP Act. Gustav. Section 18 provides for punishment for conspiracy, while section 19 provides for punishment for harboring. Harboring
Section 19.
Three years punishment.
for harboring any terrorist. Section 38 relates to
Membership of a terrorist.
a person being a member of a terrorist organization. While section 39
Support.
is in relation to support being given to a terrorist organization. Gustav. In the present case, comma, assuming that the appellant is a member of the terrorist organization, comma, the further requirement of the respondents would be to show that he was involved in the blasting of the grenade along with A1, Papu Ponch. Though so in the present case, there is nothing to show. So in the present case, the evidence already adduced does not indicate that he was involved in the blasting of the grenade. Though he might be a member of our terrorist organization. The question of harboring a known terrorist would also have to be proved during trial. Statements given under section 161, especially to police officers, are not admissible as evidence. And as such, no finding can be based on the same as on date. Though the statements made under 161 CRPC may be considered for the purpose of granting or denying bail, the same not being substantive evidence, Section 161 statements have no evidentiary value. Next paragraph. The above being said, the charge sheet filed by the respondents show that one Amrit Balav Goswami, bracket A6, who had apparently made but apparently made 101 mobile calls to other co-accused in relation to the present case has been released on bail on bail. Again, where is that? Again, I've got to look for it. Where is that? That Amrit Balav Goswami? By this court, by judgment and order dated 10/3/2021. On the ground that in the prima facie opinion of the court, there was no good ground to presume that the accused Amrit Balav Goswami was involved in the incident of lobbing the hand grenade on 15/5/2019. So besides the above, Amrit Balav Goswami was a permanent resident of Golaghat And there was no possibility, and as the court did not see any possibility of him fleeing the trial. Listen. Similarly, Prakash Raj Pawar, Raj Kaur, bracket A8, was also granted bail by this court by judgment dated 27/12/2022, passed in criminal appeal 67/2020. On the ground that
Number is probably. Second page, the number will appear, my.
136 of criminal.
Criminal appeal 130. That is.
Acha, 136, in criminal appeal 136 of 2021. On the ground that he had been in judicial custody for more than 3.5 years. No. He'd been judicial custody for, what is the reason for his bail?
Raskol bail was granted in spite of having all the materials because of the fact, my lord, that he was also a permanent resident, my lord. I'll just show you. Lord. On the last page, my lord. Taking the length of detention, my lord. They were recovered.
They were a part of a social organization, different
Yes.
organization. They were not part of Alpha.
I'm
That's why.
sorry.
Huh?
Our allegation in the charge sheet is from the organization of the.
But still it was granted.
My lord, on the close resemblance with Omid, para 84.
On the ground that,
Pay,
the case, on the ground that, his case was,
Raskol.
was similar to the case of Amrit Balav Goswami. Correct?
Yes, but. Right. No, why
Maybe.
bail was granted?
Active member. It says the active member of Alpha. Yeah. Okay. It was single bit. How many? Huh? Para 82 and 84. Para 80.
Finding is
Para 82 and 84
Yes.
of the
Yes.
judgment dated.
inner page 42, madam.
The judgment dated 27/12/2022, passed in criminal appeal 67 of 22, is reproduced below as follows. Page 153 and 150, 153 to 155, huh?
Ma'am, para 82 and 84. Inner page 40.
No, that's all, that's all. Yeah, full stop. Next. Next, in the present case, the appellant has been in judicial custody for 4 years, 7 months and 22 days. Full stop. Keeping in view the fact that only 20 out of the 177 prosecution witnesses have been examined, and the fact that the co-accused, that is Amrit Balab Goswami and so and so Kowar,
Prakash Raj Kumar.
Prakash Raj Kowar have been released on bail. The present appellant should also be released on bail. But consequently, bail is granted to the appellant on a bail bond of rupees
50,000 earlier. Earlier it was used.
50,000 with 2 sureties of like amount to the satisfaction of the
Learned special judge Nia Court.
learned special judge
Nia Court.
Nia Court. Conditions? Conditions?
Will not
The-
default in trial, my lord.
Huh?
In trial, we should not default, my lord.
Should not leave the state also.
Or my.
Not leave the jurisdiction of.
Of the bail is subject to the condition that the appellant shall attend the trial court regularly.
Without any default.
Number 2, the appellant shall also not leave the jurisdiction of the trial court without prior permission. That's all. The learned, no, the appellant shall also surrender his passport,
Yes, if any.
passport, comma, if any, to the learned trial court.
Sure.
And he shall not,
Intimate that witness.
yeah,
Intimate the witnesses.
intimidate the witnesses, prosecution witnesses.
And but we also want that.
The violation of any of the provisions will entail automatic cancellation of the bail. The appeal is accordingly disposed of,
Allowed and
allowed and disposed of. The other case took no time.
yes, that's good. I think Lordship, Madam Lordship has got a catch.
Yes.
Immediately after the current item.
Okay. The second one, though, you just said, I is, that item, that it is here, page 80 thing, please give me the thing. Page 85. Where is it? Page 85. Okay. That thing is in the other case, it is in this 340, criminal appeal 340, at page 85 and all, in the next, he says, on the prayer of the parties, list the matter.
On 25, 25, January.
On 25 January.
My
Yes, I'm not going to be here anyway. So I don't know which bench will be here. 25 January I won't be here.
As your Lordship picks, but
After the vacation.
well, let it 25, my lord, otherwise.
Okay, 25,
Much of.
25.
How about you? 25? I'm a parent for the phone number.
In which one? In the second one?
It's
In the second one, you just write, Mr. Z. Kamar appears for the
Appellant.
appellant, while Mr. D.K. Das, senior counsel appears for the respondent.
Respondent.